here. I don't know if I'd like it now with all the extra chemicals,
Sure, it's completely different.
but take a whole unit alcoholics.
Yeah.
She's getting her spot.
I know, and I'm going back in the chamber, so these guys, tell these guys are ready for me.
Dennis.
Yeah, she's hanging out. Is her head hanging out? Somebody's really, yeah.
Oh, yeah. Yeah. You have a good day.
Okay, you too. I gotta go get a uniform.
What an honorable guy. That's common pleas, very easy.
That's not that big a deal. Hey, which one?
Because it's the back.
It's great. You know what, here, have a seat, have a seat.
Is that how you get deals around here?
No, you have to ask them how the Orioles are going.
I always ask him that. They're doing better than you. They're doing better.
Is he doing a better job of sucking up?
I already noticed how the Orioles are doing whenever we talk baseball.
So you're saying I should do my
I'm
research?
an actual baseball fan.
I'm not at all. I could care less about the
I
Orioles.
had Steve Atkins yesterday.
Oh,
He was all fired up. See. Yeah, this is before they started seeing series with the Nationals. I said, they got 27 games against these the Dodgers, Brewers, the Braves, and the Cubs. I said, let's see them. Now really, there's not games.
We're there, we're close, we're 400 now, but we were chasing the Rangers and we had the series with them every week and I dropped 2 out of 3, so that's
It's moving, but a wild card. There's only like 3 teams in each league. That's really common.
yeah,
Sadly, there's one. Next one, each league.
we want to require, so I also testimony, it's all that we did Adway, so
They got the 2 best prospects in the South.
we've had the best prospects forever with what we do with them.
I like that. We're serious.
Quarterbacks.
Yeah, like 23, we were pretty good.
I thought, yeah, they won 100 games
Yeah,
with young town.
you know, I'd like to see them do like 3, 4, 5-year run. Here we are back.
It's
away.
not, window's not really close from that. It's Peter Angelo's still. See the terrible one. Cause I was a Brooks fan.
It was,
I was with this there. Every time I saw River Fountain. Yeah. So my best friend also is from his brother's chaplain. On the police department. And how we can use it, street. They do this all week, brother about that. See this gated. Somewhere you Oscars. He comes. Eats his everything there. It's really very just. Here's the cow. He's down. Thursday. Street. So the guy. Already said, probably question.
it would not be, whereas in the.
But it is, straight. No one. He says this is church still. So it's not really a problem. Been more concerned out in the street. Yeah, this guy.
As they should.
He's married to a judge now.
Is he?
Yeah.
I didn't know that. No. He's a class act.
Sure. So that. I got to have someone. File shirt.
Take a while for them to call. Well,
Go on YouTube, yeah. Yes, you're live. There's always conversations.
I didn't know.
So now everybody.
Um,
We need to talk to the judge about anything on your case.
Just, I sent you see the motion.
I did,
Just for,
I saw the motion for the, jury review.
motion for, specific.
Correct. And I guess what was, it wasn't clear to me what the reason. Desire was for the jury review.
Just kind of see what was heard. Because we have. It's not gonna take like it's just.
So are you wanting to get out?
Yeah.
So not going to.
Just stop at this place.
Here's some sign back where you bring.
You're done now.
No.
They want to jump over. No, really, what's the last one?
On the rest of them.
That's the one, right?
19 years, no one's asked for you.
Well, here.
Those are the basic, is it? This one, also, the deal, not most of it's a, what do you want? This is walking down. Round. Issue. And not like it, our past stops. She's a medicine guy. She's. He got strong, he was not losing. Not sure, he calls on him. I'm just trying to not too long. She started out part of the road. She didn't walk very through. She walked by. She didn't have. She's. Yeah. So he. She. So he let it go, so start trial. So he was transit buses. I don't know the and it is an absolute downfall. So we tore between statements. Those minutes, one of the jurors walked on, good punch. Right. It goes very easy. He was back. So, yeah, it was a plan. He went clear around the state and fine, he had a bail out there, and he tried to find the state.
Was it alleged that the victim was walking around the stadium or?
He didn't have shit in anything.
Black guy, this one for his exercise.
So going to there, we get crazy violence in the school. He did everything by signs. He's closing down, he put a slide up for people, talk about the sign, he did a sign, that was always fun. So, one of this is, how much time did we police department and go to your, which is like 5 hours. 100 slides in hours. He said, like more like, he said, we can't limit it. He goes, I would not take it. And I said, you should research on that tonight. Right. Or this week, I had a really nice day. He said, do you got any this? He said, no, I didn't have time to look for it. He said, well, you can sit at one meeting on that. Then you need to tell me how much you was doing. So he's mad. I said, he starts his Suppose you run these sets. I've got a lot of things that you got, I've been limited because somebody won't give me enough time. So then you thought, oh, he runs out of time. Yeah, it's just a few months. I got time, sit down and, all right, well, it should be. I know her butt has the whole, you know. I just can't imagine. He got those, I'll be all covered, show thumbs. We have big, like, stuff. I don't want to tell you not supposed to do it. Oh, some science guy. Oh, some science guy.
Colors come up.
Yeah, that's all I would say. Science. That's the one where you take the jury. He was trying to talk about.
This is what we're in, or not? What was the DNA evidence on?
He was trying. He was up together, he might not know what talking about. Well, no, we. So,
Good. Why are you trying?
I thought it was
You got it, no, it was you. Oh, come on. I don't figure out that word wrong. You too. We all know that.
Okay, so wait right here.
Do you need to? Yeah, talk to the judge.
I mean, probably.
I just want you to move on.
I don't know how to tell if mine's on. Sounds on. Mine, so they can't hear me.
We can hear you. Where do you think this back there? Was your issue certain further control on us? It's just not everything. Machine rate starting. So I'm supposed to be saying.
Yeah, of course.
Right, still a black screen. Why can you hear me? Oh.
Thanks, Steve. All rise, please.
Will be placed, will be placed. Thank you. Please be seated. We have to get the recorder going.
State versus Holstringer.
We are on record in the Meigs County Common Pleas Court in case versus Holsinger. It is case number. Computer's being a little slow. I'm gonna look on here.
25 CR 66.
25 CR 66.
Yeah.
For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand, sir. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, you have to speak up if you would, Mr. Finley.
This on, Judge?
No, it's not. If you push it.
Uh,
Just state your name, please.
Larry Holsinger.
Okay, and did you write down your address and give that to the bailiff?
Yeah.
So, and that information's accurate?
Yeah.
Okay, and your counsel?
Thank you, Your Honor. Jeff Finley, 435 Second Avenue, Gallipolis, Ohio.
All right, and for the state?
Yes, Your Honor, James Stanley, Meigs County Prosecuting Attorney here in the City of Ohio, along with Assistant Prosecuting Attorney at the LLP.
All right, and there would be a victim or victims in this case?
Yes, Your Honor.
Was the victim notified?
Yes, Your Honor.
Victim present?
No.
Expected to be?
Expect her to be, but we're just announced.
Okay.
Just check the hallway again.
There are some people in the hallway, but do you want us to check one more time or?
No, I just came back to you.
Okay.
It's on record, so I didn't see him.
All right, well, we're here for a status and final pretrial before the jury trial, which is scheduled to start 2 weeks from tomorrow.
Correct.
2 weeks from tomorrow. And I think there are a couple motions that are pending. So if you want to discuss those on the record, we could go ahead and talk about those.
Yeah, Judge, and I don't think these are being posed, but there, first motion was filed on sixth. Is a motion for a jury view. It's expected testimony here. There's gonna be a route here which has contact with my client had contact with the alleged victim and others. It's not that far away. I don't think it would be an inconvenience or a burden on the court. I'm sure Mr. Peter can get all this arranged, make it work smoothly for the jury. But it's just out here on Row Road is where we would be starting. And I've kind of done here in the motion turn by turn directions or stop by stop that will lead just a certain back to the courthouse. The second motion, which was just a motion for a more specific bill of particulars, specifically pertaining to counts 2, 3, 4, 5, and 6, 7. With respect to those, as well as the same crime is charged, but the conduct is not specified, which I get it. That's probably something that state did not want to make public record at the time, but now we're up pushing the trial. It's going to be needed to prepare jury instructions anyway, so and I don't care if that gets filed as long as I receive it's filed. The clerk's office's office.
Or that part under seal.
Or under seal, whatever.
No, that would need to be, because it's just gonna be various sex acts, right?
Correct.
Yeah.
So I'm fine with that, just as long as we know. So I can prepare the jury instructions count for count.
Okay.
Those are the only two outstanding issues that I see right now. Judge, I did provide Mr. Stanley with some other discovery, but I don't think it's anything that doesn't have, so. And then we'll download the exhibits, in plenty of time ahead of time.
Yeah, we'll talk about that in a moment. So, Mr. Stanley, your response?
Yes, sir. And after clarification regarding the motion for a jury view, in which the jury would just remain in the vehicle and not get out on the victim's property, the state would not oppose that. Regarding the motion for more specific bill pictures, the state can prepare that, provide that, file that to the court, provide that to the defense counsel.
Okay, and when will you be able to do that?
Tomorrow, today, I'm.
Yeah,
like 20 some cases.
I know, yeah. I know it's a busy day.
And Judge, that's fine. I don't think the end of the week's fine.
Okay, so yeah, by the end of the week would be
We
great.
have discovery. I just don't know which
Yes, right.
count he's gonna put.
So I know he's preparing for another jury trial next week too. So yeah, if you want to just take even till the end of the week, I guess you were saying that's fine.
Yeah,
He's
that's
gotta have
fine, man. And I discovery, I just don't know which act's gonna go with which count.
it right. And speaking of making sure we're fully prepared, and again, knowing that you're up against it with 2 jury trials week after week, when can we make sure all the exhibits are loaded to case center?
I'll spend that tomorrow. I'm working with that for the other case as well.
Okay, and then likewise, when could you have yours?
We're working on it now. We don't have to.
Yeah.
It's not like the last one we had where we had.
Yeah.
Under or whatever.
Yes, there were a lot of exhibits. How about, do you know yet how many exhibits you potentially have?
I'm not sure how many I'll actually upload.
Okay, but again, if he has it by the end of the week, that's
fine.
close enough.
But it's been split.
Yes, right.
So how it numbers.
And proposed jury instructions, the ones that are not just your basic ones, can you were talking about jury instructions and verdict forms. Can you do any proposed ones you want to by date certain?
No, yeah, I have. It's not that.
By next Monday? Okay. Be great. And
Is the jury list available now?
Yes, Amanda would have that. But as you will recall, what we have been doing is we summons the jurors in, and as we check them off, we're going to give them the questionnaires to start
Right.
filling them out. And I don't know what numbers we have summons for yours, but we have an overflow area that we can use now where we send the folks that would get called later, and they would be able to watch us remotely, start the jury selection, hear all the indoctrination information, get sworn, would be able to not have them use your juror numbers so you can find them easier. And because they'll have a card with them that says this is our juror number. So, and none of that will be televised. None of the jury selection, of course, all the microphones and cameras will be off during that. But we may be filtering people from the courtroom, eventually filling in from the extra room coming in here. Just, it's a little bit different because we know we'll have to have a
But
large.
the list is good.
It'll be
Just
everybody.
like the
Yeah, but, and it will show anyone that was already excused if they, over 75 or have medical excuse. Yeah, she would have the ones for that week. All right, anything else from the state?
No, Your Honor, thank you.
All right, anything else from defense?
No, thank you, Judge.
All right, with that, then we'll see you guys 2 weeks from tomorrow. Thanks. Next, we have Mr. Richards or no,
Yeah.
Mr. Young for Raymond.
No, yeah. She has 2 cases, Your Honor.
Thank you. Come on up, have a seat.
State versus Young.
We are on record in the Meigs County Common Pleas Court in 2 cases, both State versus Young, cases 24 CR 093 and 25 CR 085. For the record, I'm Linda Warner, the Common Pleas Court Judge. If you would please, ma'am, raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I did.
Okay, state your name, please.
Shut on you.
Okay, and did you fill out paperwork that showed your name, address, phone number, and
ma'am.
email? And did somebody make sure it's legible for the clerks?
Yes.
Okay, good, because I know they want to just to have us double check that. And you're here without an attorney at this point. We'll talk about getting you one if you need one appointed in a moment. We do have the state's attorney.
Yes, Your Honor. James Stanley, Meigs County Prosecuting Attorney, here on behalf of the state of Ohio, along with Assistant Prosecuting Attorney Abigail Gilpey.
All right, and there's no individual victim in one case. Let me pull the other one.
I mean, 2 copies.
No, there are no individual victims. So you were indicted, Ms. Young, on 2 different occasions. The case number 24 CR 093 was May 8, 2024. It's a 1-count indictment for possession of drugs. Did you receive a copy of that indictment?
Yeah,
Was it more than 24 hours ago that you received a copy?
I thought we didn't hit that one case.
Okay, wait a minute.
Should be for a PV.
Okay, I'm sorry. Yeah, I'm just trying to get somebody muted that's on here. They need to be muted. Sorry. It is on a PV. I'm sorry, I got ahead of myself. So both cases have a PV pending. So it's much further in time, right? All right, so did you receive a copy of the motions to revoke community control? And
No, I haven't.
we're gonna get those for you. Can you print those out? How did you know to come today?
I'm at rehab and they told me
Okay, where are you currently in rehab?
field trip.
Okay, good, good.
Yeah, I set this up because Brittany asked. me to do
Okay,
that.
that's fine. That's a good thing. So the memorandum in support is that you had a positive test for amphetamines
Yes.
and was confirmed by laboratory. So that's the basis of it. So you're familiar with the basis, but I want you to take a few minutes to look at the actual motion and memorandum and affidavit before we go further. So once you get that, let me know when you're done reading it.
While she's reading those, we have 2 people in the court. Do you want to do those before the inmates or next month?
Yeah, we'll just go in order.
Go in order.
Yeah. All right, did you finish looking at those? All right, so you're familiar, I already told you basically what it's about, and you were familiar what this, the chart, the allegations were gonna be
Yes, ma'am.
correct. I'm gonna enter a denial on your behalf at this time, and you need to have an attorney to assist you through the process. If you cannot afford one, one can be appointed. Are you gonna be able to hire your own or need one
No.
appointed?
Right.
Okay, we'll have to make sure if you haven't, you fill out affidavit showing eligibility when the bailiff's back in here, we'll make sure that you fill that out before you leave. And assuming you're eligible, we'll appoint
Rick Wiseman.
Attorney Britt Wiseman. And we'll give you his is that who you had in the original case? So you have his contact information or you need it still?
Give it to me.
Okay, we'll give that to you. Next, we'll talk about bond. What's the state's position on bond?
Yes, Your Honor. I believe you're in treatment right now.
Yes.
Still to hope, she said.
So, I don't know how the court wants to handle whether to the $25,000, 10%. I guess just do no R actually with her being required to remain at the treatment facility to further order the court to be a safe recommendation.
All right, the state is recommending that you have a much better situation than many that come before the court on motions to revoke community control because you've already gone voluntarily to treatment. So they're asking for an OR, personal recognizance bond, and I assume you have no objection to that.
Yeah.
Okay. The conditions of that bond will be, first of all, that you remain at and fully in compliance with the programming at the Field of Hope, and that they'll bring you back and forth for your hearings. That you, of course, cannot use drugs, alcohol, or other mind-altering substances. Your firearms disqualified. You cannot own, possess, acquire, use, or attempt to do any of those things with firearms, and you can't get any other trouble. No contact with law enforcement resulting in charges or arrest. Additionally, because the underlying allegations involve a felony, getting an OR bond means it's really, really important that you make it to all the scheduled hearings, because failure to show up at a scheduled hearing could result in an additional serious felony. So do you understand those conditions? And we'll schedule hearings for.
Set the probable cause and final PV hearing for September 14th at 3:15.
And she wanted to, yeah, you got it. Thank you. You got your Jim's card. Not Jim's, Britt's, Mr. Wiseman's card. Just go ahead and stay there for a minute. What else does the state need, if anything?
I don't think anything you're thinking.
Hey, you can't leave yet, though. I just want, because you have to sign the bond paperwork.
Oh.
So you have to wait till this all gets processed. So you'll just have to stay in the courtroom until the clerk comes out to get you. I assume she was fingerprinted properly, or you would have noted it. Fingerprinting's done on her, or did you check them?
I will have to check on the PVs.
Okay,
She would have been on the original.
yeah, I just want to make sure we're not neglecting any of those. So if you'll just have, do you have any questions? Okay, if you'll just have a seat, I'll keep watching the electronic docket here and get that signed, your orders signed for you to be bonded on an OR bond, and then you'll be able to sign that and leave. Okay, thank you. Who do we have next?
I think that was pre-trial, initial pre-trial this morning.
I thought we had one more. Well,
Well, 11:15
okay.
or 11:30.
With Richard's 3 cases.
Do we need to go on record with them?
Probably.
Oh, I don't know. I'm just thinking of an order.
I'd say we might. So then that's Petrov, so we'll need, and maybe we'll start and stop with people, like we need his attorney, Petrov.
Okay, he's just went to the jury right with her. I'll check.
When he said went to the jury room with her, is that on the Haining case? So he may need to spend a little more time, I assume, with her, so I have this civil case, I'll do some of that in between you guys, once you're at the point where we won't put anything on record, just interrupt and we'll take a break on the civil case.
If we don't need to put anything on record with her, do you still want?
Yes, yes, all those cases I like them. Somebody. Got it. Sorry, but Mr. Richards on here.
And that's when he just needs new dates and he had to talk to her. So I jumped the gun. I just took them in order. I'm sorry.
That's exactly what I'd said, so you're fine. Mr.
He needs next, and he obviously needs to talk to her.
Yes, so we'll take a break, let him do that to my civil case. But a little bit out of order, so. Ready on, Mr. Richards?
State versus Richard.
We are on record in the Meigs County Common Pleas Court in State versus Richards, 26 CR 022, 26 CR 051, and 26 CR 081. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Please state your name. Okay. Did you fill out a form with your name and address, and is it legible?
Yes, sure.
It says, okay. And the last lady that was up here, Miss Young, she needs the court-appointed counsel form if she didn't already fill that out. She does. Okay. So Mr. Richard, your attorney is going to identify himself,
Scott Petroff on behalf of Linda Richards.
and for the state.
Yes, sure. James Stanley, Mexican prosecuting attorney of the state of Ohio, along with assistant prosecuting attorney at West Hilton.
And this case would involve victims or victims. Are they identifiable? Okay. So with that there, we are here back on initial pretrials because there are 3 separate indictments. Are we able to proceed as scheduled? Are you good about timing as far as exchanging discovery? I know it's 3 different cases and it's kind of.
So, Your Honor, we've received discovery in 26 CR 22, 26 CR 51. We received the state's reply to discovery for the newest case. That case will include some discovery that will have to be reviewed in person, prosecutor's office, but we're still waiting on the police reports and those sorts of things, the paper discovery for the newest case. So waiting on some discovery here. I've talked to my client about this issue. We're prepared for a task for continuance. There's one of the cases is a drug case. Anticipate there's going to be a plea to that count. So my client understands it's not going to be soon. So the 2 newer cases and then more serious cases. So we just need time to.
Do you want to schedule that plea now, or want to wait and see if you have some universe?
Yeah, we'd like to try and get a global resolution if possible.
That's fine.
So we could just continue pre-trial dates, all 3 of them. I can give them a shot at that.
Another initial rather than going to a final motions hearing in case, because you don't have all the discovery to know whether you want to final motions. State's response to those issues?
Say that's, it's not, my knowledge, we've mailed out everything that we can, or some things that Mr. Petroff can come to our office to view.
Yeah, and he acknowledged that some things you have to come see. But what was the issue with the last discovery? Have you not received the last case? I'm sorry, the 81 case.
The last case, we just haven't received it in the mail yet.
Okay, it's been mailed, but
That's
Okay.
my understanding.
it's
mailed.
been snail mail.
Yes.
We just mailed on July 15th, so I'm not sure what it was.
Okay, then we may need to have it electronically transmitted.
The only news that there would only be a few things that are different that wasn't already provided in the other case anyways, but.
Would it be possible for someone from your office, because Ms. Petroff's going to be here for a while, to duplicate it, maybe bring it down, Alicia or someone, to hand it to him today? Or is it because you've got the file, that'd be hard?
It'd probably be pretty difficult to try to do it today without me being there and telling them.
Okay, that's fine.
And I'm back on Wednesday.
Okay,
So if we.
he could, yeah, maybe if you could have someone duplicate it. In case it got lost in the mail somehow, because you're right, he certainly should have had it, even with the US Postal Service being more slower than it used to be. He should have it by now. Nearly a month. So you're fine to just get it on Wednesday, Mr. Petroff?
Yeah.
And you're preparing a waiver of speedy trial?
I am.
Okay, so we need to set another initial pretrial, another final pretrial motion hearing, and a jury trial date far enough out that they can work on a global resolution. So we'll work on getting those dates with your calendar, both of you.
So do you want that like a month out, or how far do you want to go?
I would expect we'll receive discovery in a month.
Well, yeah, you're gonna get it this week.
Right.
Yeah, so
So I'm not too fine.
for another pretrial in a month.
Yes.
Okay, it looks like you're here. Oh,
You're on 15th, yeah, yeah.
I know, but I have no prosecutors, which I'm thinking might be a date that James gave me recently, 14th and 15th of September.
That's a training deals.
Yep, so I don't think we're gonna be able to do any of those on that day, so let's pick a different day.
Wait a week later.
Yeah, let's see.
We're gonna have to debate, we've got a trial date, it looks like this will have to vacate.
Right, well, I figured that with the waiver, you're gonna be getting a new draw date anyway.
Are any of those trials going on the 22nd of September? If not, I could set it.
Patton, Stumbo, Dalton, Roberts, and Haining. But that's Mr. Wiseman said it's Mr. Haining. Just probably not gonna go, they won't be ready for it by then. Are any of those yours, Mr. Petroffa?
No, this is mine, I'm open that day all day.
Alright, let's just set it and then we can always continue it if any of those go.
What time?
What about September the 22nd at 9? For an initial pretrial. What about October the 26th? For a final pretrial motions hearing,
Sure, October 26th.
yeah, 10.
Yep, that works for me.
Alright, and then November 17th for a jury trial at 8.
So. What was the jury trial date you said?
November 17th.
That works for me.
Okay.
So those dates are all gonna be on this entry. Mr. Richards, your attorney's gonna go through some questions with you to make sure you do understand exactly what you're waiving. As far as the speedy trial rights, and with that, then you can go ahead and inquire.
Okay, Woodrow, you and I have talked before about this case and about the need to have discovery. In fact, you've got 3 cases, right? Yes. And we've talked about your speedy trial rights, right? Okay, so this form, you've got a constitutional and a statutory speedy trial right. We're gonna waive those between pause on the clock while we do this continuance so we can do the discovery. You understand those rights? And you would like to waive those rights to that? Okay. And so putting on this document, we're gonna continue this to September 22nd.
Yeah, actually, basically continuing the whole case till November 17th, jury trial is the date you would put at the bottom, because
I got you.
that's the date, the
Sure.
end date, so I think that would make sense.
Okay.
Do you have any questions, Mr. Richards, about your speedy trial rights? Okay, and you feel like you have a complete understanding of those and what it means to waive, because you're in jail, so obviously we try to make sure that we're moving things right along when people are incarcerated, because you're getting every day you're in jail counts for 3 days for speedy trial purposes. You know, I'm sure your attorneys talked to you about that as well, is that correct? Yes, okay. Do you have any questions for the court? All right, with that, then, we'll go ahead and remand you to custody. Anything else from the state or defense counsel?
No, you're
Thanks. I know you're talking to another client. Go ahead. We do have a civil matter that will, when you get to the point after you're done talking to her, I don't, even though it's an initial pretrial, it's on a murder. So I want to make sure we come in on the record. And so,
This should be fairly brief. I visited her in the jail. Commissioner Burge with this.
yes, thank you. Thank you. All right.
Want the headline?
And then, but just interrupt me on this when you're ready, because this other case could take a while, the Hendons. Sorry, I know you guys have tons of files. I don't know how we got this civil case in the middle of criminal docket. Somehow we did. Come on up on Henman versus Henman. May have to wait a minute, so someone will have to get him. Is he out in the hallway? If you need to use one of the desk stuff there, if it helps you to take that. I'm back in the courtroom either way. Go ahead and have a seat. Have they filled out forms yet?
I did not get him on, I got to see him out there. Take your time. We want to make sure we can read it, so make sure you take your time on it. The clerk has to have this to make sure that they have the correct address. And Mrs. Hinman's was legible. Yes, Your Honor.
Jim, if you'll get that. Okay. Right, we can go on record.
Record time.
We are on record in the Meigs County Common Pleas Court in the Henman divorce 24 DR 064. For the record, I'm Linda Warner, the Common Pleas Court judge. Both parties, please raise your right hand. Do each of you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth will help you God? Okay. State your name. You're the plaintiff in movement. Okay, and you provided an address in writing with phone number and email as well, and that was the information you provided accurate. Okay, and your counsel?
Yes, I'm Liddy Spence here on behalf of Ms. Hinton.
Okay, and Mr. Hinman?
Joshua Henman.
Okay, and you likewise just fill out a paper that had your address, phone number, and email, correct?
Yes.
And that information on there is accurate? Okay, we're back again on a show cause motion that was filed
June 24th.
June 24th. I do have it in front of me. Has there been any discussion on resolution, or you just need to proceed to contested hearing?
I think we need to proceed, John.
All right, with that then, do you have any opening, or are you gonna just go ahead and call your first witness?
I can just go ahead and call my first witness. I think the information will be pretty obvious once we get into it.
Okay, and I just caution you that this is typically a criminal trial day, because Monday's off and people have been in jail and we have to deal with a lot of criminals. So this got scheduled when we also have a lot of criminal things going on. So we may get interrupted and start and stop a few times, just so you'd be aware that that could happen here. So with that, though, call your first witness.
All right, I would call Joshua Hinman.
That's Pond Cross.
Yes,
Come on up, sir. Come up here. We need to get, do you have any exhibits you're gonna be using?
I have one exhibit that was submitted to the
Case center?
case center. Thank you.
Is it in with all the old case? You just added?
Well, I think my secretary tried to get rid of all of it, but I think there may be some room, some holdover things there. It's number 4, as if number 4 is the one we're looking to find it. I guess I can go ahead and start while you're.
Yes, if you want to do that, that's
Sure.
fine, I'm
Okay.
listening.
So you're Mr. Hinman, that's correct?
Yes,
Okay, and you were married to Tamara Hinman,
yes,
okay, you're now divorced,
Is that correct?
yes,
all right, thank you. And you, were ordered to pay spousal support each month, is that correct?
yes.
All right, and that has been since, last year, is that right?
Whatever day you have my phone.
Okay. And that was reaffirmed by a court order that was filed, I believe, late last month, is that correct?
Yes.
Okay, and so how much are you supposed to be paid?
$2,000 a month
All right, and do you know what day you're supposed to be paid?
by the end of the month.
Okay, and that was essentially determined by the court last month in the court order, is that right?
Yes,
Okay, and previous to that, there wasn't necessarily a set time other than it was supposed to be each month, is that right?
yes,
Okay, but it ended up being essentially paid by the end of each month?
yes.
Okay. All right, so, in the month of February, did you pay any spousal support?
I would have to look on my cash app, but let me see.
Okay. Is that?
Did you say yes, you did, or you need?
I would have to look at that. Yes, I paid it. I can't give you the exact date, but I could look at this and tell you what day I paid it.
We'd need to be able to print it out. Can you email it? Whatever, pull it up and whatever you're gonna testify to.
It's just the history. Like it showed, by the way, you said show history, I paid it.
Right, but I can't, unless you want to give me your phone and your passcode to put it in evidence, I have to have the documents. So if you
Well, she would
pull,
have the day it's in there too, right?
you're the witness on the witness
Okay.
stand right now. And so you need to produce what's requested if it's available to you. Now, she didn't subpoena this stuff. I understand it may not be readily available, but if you do have it readily available, I'm gonna have you find it on your phone and email it.
All right. And.
So he's looking for it.
Okay.
you wanna
so
wait?
Just wait a minute and let you look for it.
And so then if we can have him email it to the exhibit email and Andrea bring them in as their email to her. Well, then I could just pull them up, I guess, if I'm just gonna use that.
Lunch, but
And I can actually do it through here. I'll just open the email as opposed to the case center. That'd be a quicker way to get it to us. Are you having trouble finding it?
Just going through it. Thanks.
So right now she's asking about February 2026. Are you gonna be asking this for each month?
No, essentially, there's only 3 times that I believe.
So if you're gonna ask for February, what other ones?
February. Also for May,
February, May,
yes, and November.
and November.
Mhm.
You find those three and then, do screenshots and email them, that would be great.
Oh, he's on the stand.
Whomever's on here needs to be muted or you'll get kicked out. On Zoom, I want to say on here, on Zoom, you must remain muted the whole time, anyone on here. Found any of them yet?
Yeah, well, I thought it was on all at once.
You can't just search camera.
That's what I just did.
It was February, May, and what was the last one?
February, May, November.
So November 25. Didn't we already deal with that in the last contempt? In fact, didn't we deal with all of them? Did we deal with all of them in the last contempt?
Not,
So you're contending you
Just-
didn't deal with them in the last
well,
contempt?
Your Honor, yes, we dealt with them, but the court order said that he was supposed to pay extra. But so we need to have an established number
Okay.
from the court.
That's
as to
20%.
what's up.
It's 20%. I can tell you
Yes,
that, it's what we do
right.
on child.
So then we just need to see, like, if he didn't pay, say, 3 times, would that mean then $6,000? And
Yes, and then you take 20, add 20% to the 2,000 per month.
right,
To
would be
till that
another 400.
until that 6,000 is paid.
Right.
Like we
And
do
I
in child
think
support
we
cases.
just need some clarification for everybody as to how much is owed. That's part of what we're getting into, Your Honor.
Okay, well, obviously it's res judicata if you've already done some of these things, but to the extent that you want clarification.
Right, that's what we're doing. We just don't, we never really had the judge, Your Honor, to say, did Mr. Hinman pay? If he didn't pay for November, which is what we contend, if he didn't pay for February, which is what we contend, and then there's another issue having to do with May.
Like, I don't see like paid February.
So you don't think you paid in
I
February?
just don't have, I don't have a thing.
Did you pay in May?
Yeah. March 31st, April 30th, June 2nd, June 30th, July 31st.
Did you do screenshots and
I
not
got
give
to send them all.
Your Honor, if I might help with this.
It sounds like he tried to pay May at the beginning of June and then June to the end of June.
Yes, our exhibit that we have for you, it shows that there was no payment for May, but there was a payment in June, 2 different times.
So, yeah, that sounds like he intended, because he didn't make it by the end of June or end of May. So he did it at the beginning of June and at the end of June.
But-
Don't, right now you're not talking. What were you gonna say, Ms. Spence?
Yes, and that's, we're not saying that he didn't pay, but he paid late.
Okay.
And as paying late, and at the time this was filed, we hadn't received anything, so we didn't, or we had received something, but we hadn't received it in a timely manner. My client, in the essence, Your Honor, is in a situation where she doesn't know when she's gonna get her money. If Mr. Hinman has some financial issue, I suppose that's what he's gonna say. Then he just doesn't pay, and my client can't rely on him having trouble because she doesn't know when it's gonna happen.
And that's why in that
He wants
last,
him to be held to account for it.
and then that's why in the last entry, since that pattern, since there was not the specificity in the agreed divorce decree, then I had to decide it after the fact.
Yes, Your Honor.
And what I
understand.
decided after the fact, the pattern had been paying by the end of the month, so that's how I kept it. So the expectation would be by the end of the month, it has to be paid, and if not, then it's in arrears, and then you bring a contempt and so on. So none of these have happened since.
Yeah, one of them, well, We filed it
in June.
before the court had issued its decision.
Okay,
It was after we had our
Yes,
last
I know, I
hearing,
know.
but before.
so
we
your
had our-
contention is that you really had one new contempt because he
Yes.
hadn't paid on, even in the month of May.
Right,
He hadn't paid till early June. Okay,
Right,
I got
right,
it.
that's what
So
we-
you want me to
that's
find him in contempt for that?
yes,
That's
sure,
what you're asking.
yes.
Okay, well, now you can ask him some questions next and he'll be able to testify later. Okay, go ahead and type it in yourself. It's Meigs, Meigs. Court. Exhibits, which is EXHIBITS, and I can respell that for you if you need to. Meigs Court Exhibits, Meigs, okay, at gmail.com. Bless you. Tell me when you send it, I'll keep watching for it.
So I guess, Your Honor, if we could have you to pull up that exhibit that we submitted.
Yeah, I had it
That
up.
would be my client's cash out.
So that shows, it doesn't have dates on it though. Friday, well,
Uh,
that one, the top one says Friday.
Yeah, that had just happened like at the
This does show,
June.
this shows June 2nd, June 30th, is that in 2026 or not?
Yes,
So your client can testify about that, that's her exhibit.
yes, yes.
He's still trying to send what you've requested of him
Okay.
on the stand.
Okay.
If you're gonna keep coming back to court, you might want to subpoena or whatever.
I obviously see that.
Did it go? Good. Sent.
Well, this is second.
Once it's sent, I'll let you start asking questions, but I wanted them to be able to concentrate on that.
Yeah, both of them signed.
They're sent. Okay, they've been sent, so go ahead. I'll watch for them. Oh, wait a minute, one came up already. So, Mr. Hinman, is this in response to the question?
Yes.
Okay, well, tell us what we're saying. Tell us what you showing on there.
That is me sending the Alma.
Okay,
So
what day and what year and what amounts?
So 2,000 for March, 2,000 for April. 2,000 for May, came on June 2nd. My direct deposit hit June 2nd, that's the day I gave it to her. Okay, don't have a way to get money quicker. And June 30th again for June.
Okay, and then the next exhibit. That's the same one. So you said you sent two? Did you send two exhibits to me or just one?
Sorry.
But I think that corresponds with her records. So
It
with
does.
that, then what's your next question?
July 3rd.
Okay, July 31st, and does your client acknowledge getting the July 31st one?
Yes, she did.
Okay, with that, then next question.
Thank you. So, Mr. Hinman, it looks like from the records you're showing, that you submitted to the court that you did not pay for February, as it shows January and it shows March, but it doesn't show anything for February. So would that be correct in saying that you didn't pay for February?
I don't have a record of it,
Okay,
but I believe that was covered under the previous.
well, Mr. Hinman, what I'm trying to get at, that doesn't mean you don't have to pay. Do you understand?
You don't talk over top of her. I couldn't hear her because you were talking. We've been through this. You guys been here a few times.
Yeah,
So
right.
you need to not answer the question until she finishes asking the question. Go ahead and ask it again.
Thank you. So, Mr. Hinman, you are supposed to pay every month, is that right?
Correct.
Did that include February?
I don't remember if that was in the
I don't
since
think,
the thing, since we've done the, I'm sorry. Would you like me to complete the statement or would you like to? talk with me?
go ahead. It's
Okay.
just that I don't think you're answering my question, sir.
I'm trying to answer the question. I'm not sure if that was in the decision that she made previously.
So
in the
you're
court
saying,
dates. I don't remember what date that happened. That's what I'm telling you.
So you're saying you don't, that you think the judge said you didn't have to pay for February?
That's not what I just said.
So listen to her question again.
My question was, you were supposed to pay every month. Is that right?
Yes,
Is February a month in the year?
yes,
Okay, is May a month in this year?
yes.
So logically, wouldn't you come to think that those are months that you're supposed to pay?
So logically, I don't recall if that was after she made the decision that this is what you're going to pay, because initially I was not paying alimony because Tammy was taken into custody for a felony and not allowed to come to the
Your
house.
Honor, I would object to that. That's not relevant to this.
Well, I'm explaining the situation. I don't
Well,
remember
you need to
exactly.
just answer a question. You'll be able to testify in a little bit. If you remember, I know you're here without an attorney, but I've explained to you over and over again, the same rules apply. So you don't argue with counsel, you answer her questions, and then
Yeah.
you come back and make any statement you want to make at a later time on the insured's side of the
Yes,
case.
February is a month that I should have paid. I don't recall if that was a date or not.
Okay, and also May was a month that you were supposed to pay, right?
Yes, and I did. I paid 2 days late.
But you understand that's not within the month.
Okay,
And
I'm supposed to be direct deposited as well within that month. It didn't get here until the next day. That was the first time I had a chance to get to her.
and you have a mortgage payment, is that right?
Yes,
And if you don't pay your mortgage payment on time, aren't there consequences?
if I paid a day late, no, there is 0 consequences.
So even if it's a month in another month,
Okay, but we're speaking about different.
No, stop arguing, just answer her questions. I'm not gonna advise you again. We've been through days and days of this. You should know
Yeah.
the rules.
Yeah, no, too.
Finish your question and only answer a question. You're gonna have a chance to testify later.
so, sir, if you go from, even if your payment's on the end of the month, if you don't pay it on that month, isn't it considered late?
There's some sort of grace period.
Okay, was there a court ordered grace period for you?
No, I'm not aware of any.
Okay, so you understand that there should be consequences for not paying on time.
Sure, there should be consequences.
Okay,
Sounds great.
all right, and you do acknowledge that you did not pay on time.
Yes, and she gave you proof of that.
And so at the very least, it sounds like you have proof on your own. From your own paperwork that you submitted, that you did not pay in February at all.
Yes, I do not have proof. that
And you
I paid
didn't
the-
catch up in another month.
No,
Okay. And you also indicated you didn't pay for May until June.
correct.
Okay. And so that leaves at least $4,000 that. Or no, $2,000, because you did pay in June, sorry, $2,000 that you owed for the month of February.
Sure.
And so you recognize that by the court's last order, that you'll have to pay an extra $400 until any arrears are paid.
Right.
So that'll mean 2,400 rather than
That sounds
2,000.
good.
Okay.
You said that's not good?
I said, that sounds good.
Oh, sounds
Great.
good. Okay.
Wonderful.
And part of the court's earlier orders were that you were supposed to set up a system through your bank for withholding through Job and Family Services. Have you had an opportunity to do that yet?
There is nothing in the court order that states that.
Let's see here.
Actually, I believe it says that it's not set up like that because I've already been receiving that time.
Sir, I don't think you're understanding what I'm saying. The spousal support that you're supposed to pay, you're supposed to have something set up so that it can be withdrawn from your account. Do you understand?
No, I don't, because I did not read that and what she found. What I read in the last 2 times you found me, tried to find me again, is that it's all unsubstantiated. That's what that says. That's my understanding. I'm sorry, I'm not a lawyer.
All
But
right,
that's what
but
I
I
understand.
think you're getting into, once again, territory that's not relevant here. All I'm asking
You're
is
going
that
off
you
that.
have set up a way to make it easier to get the money paid.
Can you point to where in that decision?
Yeah. All right. It says in.
What's the
page
date of the
6
decision?
7,
Date of the decision.
Is dated on, it was filed on July 29th of this year. Page 6 of 7, at the very last paragraph.
Do
of
you have a
that
copy
document.
you want to show him? Or
Yes,
you want me
I
to pull it,
can.
or I can pull it up on the screen. Does that be easier? Do
I'm sorry.
you want me to just pull it up on the screen?
Yeah, that would be real wonderful. Be easier for him to see. too.
Yeah, that's what I'm
Thank you.
thinking. Hey, Ms. Bench, you were calling his I pulled it up on the screen for everybody.
Yes,
You
sir.
called its attention to which page?
Page 6. At the bottom of page 6.
Okay, we're on page 6 and I'm at to the bottom.
All right.
So
So.
it's orders. Is that where the orders actually start?
Yes, ma'am.
Okay.
Yes, ma'am. And I would draw your attention, Mr. Hinman, to the very last paragraph. Can you read what that says?
Benefits-based spouse support each month commencing September 2026, the Meigs County Department, Fair and Family Service, Child Support Enforcement.
All right, so have you had an opportunity? You're not supposed to have that until September, but that's only less than a month away from now. I didn't know, I wanted to find out if you had that set up so that you could make it a little easier for you to pay.
Is it yet?
I'm sorry.
Question, answer question. Have you set it up? Yes or no? Okay, that's all we have to do is just answer the question. That's fine. Thank you.
All right,
But he knows now. If he had forgotten, he knows
I
now.
was
He
unaware.
better.
Thought-
Did you not read through everything?
I did, but I thought later on it goes to state that because my
The retirement's that's a whole completely different issue. That's a
That's
whole,
how I understand.
it's a whole.
Sorry.
completely
then essentially, I guess, sir, what I would suggest to you is just look at the part that says the orders in terms of things that you and Miss Hinman are both expected to do for the future. All right, so until this time, you have been doing through the cash out, is
Yes,
that right? Okay. And do you see that working through this child support enforcement agency, family services department, job and family services department, that it could be another method for you and Miss Hinton to both keep track of where payments are, that kind of thing?
sure.
Okay. And so you plan to go and take care of that now that you know about it?
Obviously.
Okay, all right. And, you also recognize that by not paying, you're causing Ms. Hinton to have problems with her finances?
How was that? I have zero understanding Mrs. Hinman's financial situation.
Okay, all right, but, would you, think it reasonable that she would have?
I don't have.
Oh,
Yeah,
any.
you think it reasonable? She didn't finish her question again. Wait till she finishes. I didn't understand what she's asking. At least let her
All right.
finish.
Thank you. So Ms. Hinman has to live on this earth, right?
Sure,
Okay, and normally for us to live every day, there's some kind of expense that's involved in it, is that right?
yeah, that's why we work.
All right, and so since Ms. Hinman is a human as well, then she's gonna have some kind of expenses that are involved in being a human. Does that make sense?
I have zero understanding or opinion on Mrs. Hinman's financial situation.
All right,
Deal with that.
but you've been ordered to pay
Okay,
with the idea that she has expenses.
okay, I've been ordered to pay, yes, that's correct.
Okay, All
The
right,
opinion on what she does with her finances or how she exists is irrelevant to me.
okay. But if she doesn't receive any money from you, do you recognize that that's gonna make her life harder?
I have zero understanding or appreciation or even care less about how she survives.
Okay.
But if I'm ordered to pay, yes, I'll pay.
And you understand that you have paid within the time that the court's order?
We've already established that I missed
Okay.
1 month.
All
All right,
right.
that was a couple days late.
Well, and
Can't change my direct
you were a month late for the other one,
Yes,
so there's 2 months after.
so we've established all this. What else can I ask the answer for you?
All right.
You can wait till she asks another question and stop trying to argue with her. This is the last time I'm gonna remind you, you might have to go see this guy for a little while until you get the instructions down. This is
Okay.
not the first time I've given you the instructions. So with that, go ahead if there's anything else relevant to this contempt.
All right, I've nothing further right now.
Okay, go ahead and have a seat. You're gonna get to testify.
Yeah,
I
that's
was
good. I know.
cutting you off for your questions, but trying to
Okay.
remind you, you still have the time to say your step piece on your side of the
I
case.
get it.
So any next witness of any,
Yes, Miss Hinman, I'm calling her.
come on up. The prosecutor's not ready on this thing, is he? Just, well, I'll have Jim do that. Jim, just if they needed to come in on Haining, this would be a good time as we're transitioning between witnesses.
Yes,
So before you ask, just in case, I don't know that it'll take very long. We have a lot of people. I think that's the only reason they're here. So they probably don't want to hear about other people's post-divorce matters.
I guess I could have Miss Hinman identify.
Yes, that's,
herself.
yeah, we might as well.
All
go
right.
ahead.
Miss Hinman, can you tell us your name?
Tamara Hangman.
Okay, you've already told us your address and by written. Okay,
You can go ahead. You can
Preliminary
get it in.
things.
Yeah, go ahead and get in and do it.
okay, go ahead, start, all right. So, Ms. Hinman, you are divorced from Joshua Hinman,
Yes,
all right? And part of the court orders in your divorce were that you were to receive spousal support, is that right?
yes,
Okay. And the court has established that it was $2,000, pardon me, I can't get it right. $2,000 per month, is that right?
yes,
And that it was to be paid by the end of each month.
yes.
Okay.
Okay, good place to stop. Let's have you step back. Because we have the folks in here that are gonna need to do a quicker hearing, then you'll be able to get through all of yours. So if you'll go ahead and have a seat, sir, we're gonna take a brief recess to deal with another case. You folks need to go out in the hallway to talk. All right, we're ready.
Correct.
We are on record in the Meigs Common Pleas Court in State versus Haining, 26 CR 079. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Sarah.
Okay, keep your hand down. Did you fill out a piece of paper that had your address, phone number, and email?
Yes, Your Honor.
And was it provided to the bailiff?
Yes, Your Honor.
Okay, so with that, then your counsel is going to identify himself.
Scott Petroff on behalf of Sarah Hannon, seated to my left.
And for the state,
Yes, Your Honor, James Stanley, Meigs County Prosecutor in the State of Ohio, along with Assistant Prosecutor. Guilty.
all right, and given the nature of the allegations here, of course, there are survivors of the victim. Were they notified? Are they present? Are we waiting for anyone else or? With that, then, we're here on an initial pretrial, but because of the serious nature of this case, I want to just make sure everybody was in the same room at the same time and on the record in case there are any issues. I don't want to have to wait till the next hearing. So as far as the state is concerned, was there anything that needed to be reported or addressed at this initial pretrial?
I don't believe so. We've had some discussions this morning regarding some discovery issues as far as videos not being able to be open. So we'll address that, Mr. Cottrell.
So was the format had to have a different reader or something?
I believe, I'm not sure what the issue is actually.
Where were those videos originated?
What do you mean?
Like, or are they just body cams from the officer?
No, I can speak to it. So we were discussing a couple
Okay.
different cases. There was one case
Okay.
that's separate from this that dealt with body cameras.
Okay.
So we were having problems with which video player, but
Yes,
that's a
okay.
separate issue. The cell site, look, I did receive the USB on Friday afternoon.
Okay,
So I haven't had the chance to go through the entire thing. I've been able to access some interviews, those sorts of things. One file that I wasn't able to open that I had mentioned to Mr. Salmon today was the cell site location data.
Oh.
It's a compressed file. There's other compressed files within the USB that I've been able to open and access. It's a fairly voluminous file, I would expect, so that's something that I can work out with Mr. Salmon.
well, that's what, yeah, it's whoever created that file. That's why I was asking who, if it came from BCI, if it came from what entity, might be able to help decide what kind of reader it has to have. So you're aware of which one it was, then which exhibit?
I would have that, and. So I don't have that with me today, but we have it at the office, yes.
And do you have a time you're gonna go anyhow on,
So,
Mr. Richards' case?
There is enough information aimed in the discovery that I can access that it's gonna take me some time to get
Okay.
through all of it anyways.
Sure,
I've had visits with my client at jail. She understands that this is gonna take some time to review discovery, to consider motions. And so she's prepared today to execute a speedy trial waiver so that, because we're asking for a continuance so that we can going through this discovery.
okay, and how long do you think after you're gonna need, again, understanding, and you're gonna inquire, and I'll inquire as well, that she's incarcerated, so timing is important.
We could do a 30-day continuance of the initial, if that's the appropriate. I don't know what the timeline of the other cases are, that would probably want to keep everything somewhat.
Kind of like you did on your last client, you're going to keep everything just moving out beyond, because it's going to get you beyond the jury trial date when we start doing that, because she is incarcerated, so. So when you start picking dates again in 30 days, should give you enough time to reschedule today's, just an initial pretrial, not a motion hearing, because you got to get through the discovery to see if you have anything that you want to address in motion.
30 days should be enough to be able to do the discovery. And if there are any issues, we can revisit them then, but I would anticipate get through what I need to in 30 days.
So let's, like we did with Mr. The last gentleman, schedule the dates, and then you put the last date in the waiver of speedy trial. So initial pretrial about 8 or so days out.
We'll just put it on the final pre-trial motion date. Can do that, so September 8th
September 8th,
at 11.
is that long enough?
What was the date that we picked on the other case? So we were just in, that might be nice.
I'll put it here. Yeah, and Amanda wasn't in here, but I've got it. It was September 22nd at 9.
I would prefer that much time if we could.
Yeah, I'm sure it's, the discovery's voluminous, the
Yeah,
nature of the charge.
Just quite a bit.
So September 22nd at 10.
That would work for me.
Okay. And if we're following a like schedule, do you want to just kind of parallel them?
That sounds good.
Then just so you know, because you weren't in here, Amanda, the final pretrial is October 26th at 10. And then you may want to get that jury trial date, even maybe a little farther out.
October 20.
October 26th at 11.
Okay.
And then the jury trial on your other case was reset for November 17th at 8. That, you know, to the extent that you feel like that's actually going to go to trial, would you want to make this one a few weeks after that, or how much farther out for Ms. Haney's jury trial compared to that last case?
We can set a date in 2026, but I don't anticipate these will be aired that short of time frame. So I have a preference, I suppose.
I'm sorry.
I'd imagine that's something that we're gonna revisit in the future, so if
Yeah.
you just want to put it on the calendar.
How about late November, early December? I just don't want to spread it out too much, because we'll see each other October 26th. Even if it's additional pretrial statuses, we could do that.
I'm scheduled to begin a murder trial on the 7th of December, so if we did till perhaps the last week of November,
Then
Set
something,
it for that date, I'll knowing that we're likely gonna move it.
okay. Find something what, end of November?
Oh, the last week of November, Thanksgiving, wanna do December first?
That'll work. Like I said, it's likely a placeholder. That's the date that I'll put on this document.
Well, no, we're gonna go ahead and have a jury trial date, because I wanna have it set out for a jury trial date. But
Is that not with December first?
no, that would be another status pre-trial, because you're gonna wanna do, you said it's gonna take longer. I just wanna make sure she's in front of the court. At least monthly or every 45 days till we get to trial. So if there's any issues that comes up that she hasn't been able to get access to this, or the prosecutor has an issue on behalf of the victims, that we're addressing those not on the eve of the trial. So that would just be a status hearing on December 1st. And then maybe early January or mid-January jury trial. And then again, if you have to move it again, we would do a different waiver of speedy trial.
Okay,
Would that work?
that sounds great.
Okay,
We'll do December first at 10 then,
okay, that's at 10.
and January 5th. For jury trial,
And those always start at 8 a.m.
January 3rd.
So that would be the date that you go ahead and put in your form and go through those inquiries with her, if you would, please.
Okay, Sarah, I've got a document I want to discuss with you, okay? I visited you in jail, we talked about the need to go over all the discovery in this case, and it'll take quite a bit of time, that conversation. And then today we also discussed, your speedy trial rights, right? So you have a constitutional and a statutory speedy trial, right? You have, because you're being held in jail, normally it's 270 days for them to bring the case to trial, but because you're being held in jail, you're 3 to 1, which means they would only have 9 days to bring the trial. But we're not ready to go to trial in 90 days. It's such a serious case. So signing this document, what we're gonna do is we're gonna put a pause, we're gonna time out on the speedy trial clock. You understand that? Are you okay with waiving that speedy trial, right? Putting a pause on that clock while we review the discovery I discussed and talked about the judge today? Yeah. So I've got this document here for you to sign, and we'll sign it right there. The record, which is executing speedy trial waiver.
Mary Bassini, you have executed the waiver of speedy trial understanding at this point. Rather than the jury trial date that was initially set when you first came to court, now your jury trial date is January 5th, 2027. And at this time, you're waiving your speedy trial to at least that date, correct?
Yes.
And you understand that your attorneys indicated it might be necessary to even go out a little further, depending on what the discovery exchange results in and whether there's going to be any series of any motions or anything. Do you understand that?
Yes.
Do you have any questions for the court?
No.
Have you been able to meet with your attorney regularly while incarcerated? Has he been able to answer all the questions you have? Is there anything else that we can do to make sure everybody, for everybody's sake, is ready to go to trial as timely as possible? Anything else from anyone's perspective?
I don't think so.
Nothing from the defense.
Okay, if there's no other questions, we'll remand you to custody of the Meigs County Sheriff. Thank you. And Mr. Petroff, before you leave, let's just kind of go through, I know you have some initial pre-trials that you've been talking, I think, to prosecutor about.
Yeah.
Yeah, and the only other one I thought we need to make sure we do something on the record is Lambert, because that is a combination of several things.
Yeah.
Initial, final, and yeah.
And we got a bunch on.
Oh,
You know, William thinks it'd be the easiest for us to resolve. We're gonna keep the same dates.
which one?
Mr. Stanley and I had some discussions.
Oh, that's Fink, did you say?
Yes, he's in the courtroom. We don't need necessarily to go on the record,
No.
let's change the dates,
Yeah.
but we've had discussions and expressed, so.
Okay, that's fine. Yeah, they don't, that person doesn't have to be on the record. But I do want to make sure Wolf was here or not here and then what we're doing on late.
Wolf's here.
That battery dead?
No.
Something settled in this little, but.
Hmm. Is that Mr. Fink he's talking to? Mr. Fink he's talking to,
Yes, Your Honor. Yes, what's up?
so. Mr. Petroff, if you can talk to him more late, oh, you're done? Okay.
I was trying to tell.
Who did you say you had a bond modification on?
Tony Lambert, he's in custody.
Okay, so we can bring, we can get Mr. Lambert in?
Yes, Sean.
Thanks.
Bringing.
Mr. Lambert's coming in.
So.
Ready, Mr. Lambert? We are on record in the Meigs County Common Pleas Court in State versus Lambert, 26 CR 083. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Tony Allen Lamborghini.
Right, and you wrote down your address, phone number, and email for the bailiff?
Document, I was in the.
That's all right, we'll get that. Let's make sure he doesn't have that yet, so we need to have him write that down.
I have it.
Oh, he did write it down then?
Yes, ma'am.
Is it legible?
Yes.
Okay. With that, then your attorney's going to identify himself. If you would identify yourself for the record, Mr. Petroff.
Scott Petrov.
Okay, and for the state,
Yes, Your Honor. James Stanley, Meigs County Prosecuting Attorney, Columbia, Ohio. Along with Assistant Prosecuting Attorney, not plead guilty.
given the nature of the charge, there would be a victim or victims, is that correct?
Yes,
And were the victims notified? Are they present? Did you anticipate they would be? Then we're running behind, okay. With that then, we are scheduled for a series of pre-trials and motions hearings today. So where are we on all of that for negotiation purposes? Mr. Stanley?
We don't have resolution.
No resolution, okay. And so jury trial's next. And are we ready for jury trial?
Can be.
When is it scheduled?
August 25th.
August 25th. All right, so is everyone prepared to go to trial August 25th?
The state can be, yes, Your Honor. We've not uploaded anything to the base.
I know we have another trial that we've things can start that into, so we have to figure it logistically if that's gonna happen.
So, Your Honor, we have a motion to modify bond for the court. I think that, decision whether or not we want to go to trial on this upcoming trial date largely depend on that can still us.
Okay.
All
All right,
I think
you want to,
Fair to go to trial, but we'd like to have a motion modified first.
okay, if you want to have that motion first, that's fine. Does the state have any objection to hearing that motion first before we talk about trials? Okay. Go ahead and if you want to, Mr. Petroff, tell me about your motion.
Yes, Your Honor, this time we were just asking for my client to have a recognizance bond. My client lives here locally. He's got a job with a lawn care service that it's a seasonal job, and so it'd be very important for him to be able to get out and take advantage of the summer work opportunities. I don't think there's been any issues with these clients previously or since this has happened. I know that my client has had the ability to talk to his daughter on the phone. With but there hasn't been any allegations. My client has actually contacted themselves. So we'd also just note that there's presumption of innocence here, so we just ask them to find the afford the opportunity for a cognizance bond so we can go for trial.
And state's position,
Yes, Your Honor. My office reached out to the victims, after this motion was filed. They didn't express, one way or the other as far as whether they opposed to agree to it, so the state just deferred the court's judgment.
given the serious nature of the allegation, I'm not going to modify the bond. So, with that involved, with that decision and knowing we have a trial date 2 weeks from tomorrow, are you prepared to go on that date? Do we need to let the other attorney who's scheduled for that date know if it's definitely going to go? Because we have, that was Finley from this morning. Mr. Finley earlier. We're gonna be here no matter what, so fine to do either one. Are you checking your calendar?
Look at my notes for the answer question.
Oh, okay, that's
Just
fine.
that point.
Okay. Figure out what's going on with that door. If something's happening, it's not matching, right? Have we ordered the other system for it yet, Amanda?
I have to look, I don't remember what I've ordered.
Okay. Because once we're Tom, we're talking about putting the same system on that door that having those chambers now. Be a slightly more a little before the wood. So you know, they'll be labeled chambers and jury box, so we have to get you them. Okay, if you're prepared to tell me if you're ready to go to trial, both sides now.
We are going to make a motion that it's court to get jury trial date so we can work on potential resolution.
About how much longer do you?
30 days.
30 days for it. And so I would want to schedule the jury trial date and a status before that. So let's start looking at some dates.
Jury trial, September 29th, we just took painting off, so
Would you say what?
we just took painting off that, so.
We took hanging off of that?
Off
Okay,
the 29th
yeah.
of September.
And the other one you have is Hergot. Is it gonna go though, Hergot? It seems like it would be one that potentially would go, but I don't know if you'll be ready then or not.
Yeah, I don't know if we're gonna be ready on that. But we got 29th, this would probably go before that one.
Okay, so
It's less
29th,
complicated.
okay. So September 29th for the trial or for status?
Trial.
Well, I'm asking them if they'll be ready by then. You want that to be the status date or the trial
We
date?
got status date. Time.
let's make it either at 8 or 1,
It's fine.
8 AM, okay. And then a jury trial, 2 weeks later. Oh, it's gonna be a little farther than that, probably. Probably the 27th of October, that work? We have the dailies are scheduled that at that time. I don't know if they'll be ready that quickly. If they're incarcerated. Scott, would October 27th work for you? For the jury trial?
Yes.
So those always start at 8, so September 29th, we'll get together again like this, just to see if everybody's ready or if there's an agreement or a partial agreement. And that'll be like our last meeting before we go to trial, and then about a month, little less than a month later, October 27th would be the actual jury trial date. Do you understand that, sir? Mr. Lambert, do you have any questions?
I just don't understand why I can have an alarm on me, like I ain't never violated anything. I like to be out there to help my lawyer gather the evidence that will help prove my innocence, because honestly, Your Honor, like, I'm sick and whatnot. But I like to help gather the evidence to prove my innocence, because, the victims, they come down from Oak Hill.
Okay. Yeah, you don't want to make any statements, your attorney, because anything you say could be used against you. You're here with counsel and you need to listen to his advice. So you're asking me to reconsider the bond, is what you're saying.
Yes, ma'am, I ain't got to see I've been incarcerated for 3 months, I ain't got to see my son. And I'd really like to get back out there and continue doing well like I have for the past 5 years, since the last time I've appeared in this court. I've been doing good for the past 5 years now.
All right, anything else?
And I would note that my client has been on probation. I understand that this is a new allegation, but he's been amenable to supervision. He denies these allegations, like I said. And so I think with repath or with something else, and at least one of the victims is local, so I don't know if there's a risk that there's gonna be contact with that victim. So just for all those reasons and statements in my claim, we'd have to put it.
And obviously, there's more than one victim alleged.
There's two
There's
victims,
two.
to my understanding.
I appreciate your situation. I would certainly encourage you to see if arrangements can be made for you to visit with your child from the jail if you're not able to make the bond, but I'm not going to modify the bond at this point. My
Does
bargaining
anyone
needs
need to go with the bond?
We can certainly talk about that. I don't know what,
I mean, bond in a reasonable amount to allow him to make that bond, or even 10% allowed. Perhaps, John, or something.
right now it's at with a
50,000.
with 10% or no 10%. Oh, no, I wouldn't make it any lower than that, frankly, on a felonious assault, no. It's already with 10%, so that's 5,000. That's really not an unreasonable for a felony, a felonious assault, a felony of that degree. So, no. All right, anything else? Do you have any questions other than that? All right, then we'll remand you the custody. Oh, yeah. Oh, the speech, I'm sorry, thank you so much.
So, Tony, like we talked about just now, we're gonna have a couple of options on what we want to do. We can go to trial on this date on
August.
August 24th. We asked the judge to modify your bond, so we kind of make that decision. You know that the bond was not modified, right? But we, rather than going to trial in 2 weeks, you expressed to me you would like to continue that trial date, so that could potentially work out an offer from the prosecutor, and I can look into some things that you asked me about today. So you understand that you have a speedy trial right, with the statutory and constitutional right. We're gonna waive that and set this for a trial date on October 27th. Do you understand that?
Yes, sir.
Okay, and I've got a document here for you. If you agree with that, then you will sign that document. Paperwork.
Libby. Libby Place. Libby Place. Sorry, Liberty Place.
Place. Place. Good call. Good call. All right, Mr. Lambert, I have in front of me the waiver of speedy trial, and your attorney asked you about understanding that you do have that right to go to trial as prescribed by Constitution and law, and you've signed the waiver of speedy trial. Do you understand that that means you won't go to trial until October 27th at 8 a.m. unless, of course, you have a resolution prior to that, and then we would take care of it on the record prior to that time. Good. Okay. And do you have any questions for the court other than what we already talked about? Have you been able to talk to your attorney while you've been incarcerated? Oh, you haven't been able to talk to him at all until over here?
We met here, I haven't done those.
Okay, so what jail are you in?
These are regional.
Oh, so you won't have any difficulty meeting with him there? You need any special orders for that? Okay, so I'm sure especially as you get closer and you're working on some tasks that you've given him to do, he'll be able to get with you at the jail. You know how to reach him? Do you have his phone number?
We talked on the phone, but I'm gonna give a copy of my business card.
Yes. Yeah, you should be able to reach him, and if you have something between hearings, to make sure you can talk to him and he can answer any questions, not just when you're in court. Okay, anything else from the state? Or from defense counsel?
Nothing from defense counsel.
And then the other pre-trials, you're just doing initials and you'll get me just entries on those.
No, this case is August 10th. This case was found over and indicted here on July 2nd.
Which,
So this is pretty quick for this court. Well,
Mr.
he's
Lambert's,
been
yeah.
held by the county court was the.
Why we had to do it
Like
so
this.
fast, yeah.
So.
Okay. But as far as your other clients that have not actually come up for being on the record, you need any of them on the record before I go back into the domestic relations case.
I don't think so. I'm gonna need to talk to Mr. Stanley and
Okay.
try and resolve those two cases.
We'll let you probably step out to do that, so we're gonna go help with this next, the other case then. And Mr. Lambert's back in your custody. Thank you. And then with that, we'll switch the Hinman's back up here. If we get those guys cleared out. Thanks, I know you guys are juggling a lot of different things and starting and stopping is difficult. You're asking which one's a Gaia? All Mr. Lambert is?
That's what this.
Oh, I think they switch those jails suits when they end up. Isn't that right, Mr. Stanley? Just because his jail guard says Gaia, that doesn't necessarily mean he's housed in Gaia, right? Don't they keep him back and forth, or maybe you want to check, Scott?
Think,
Um,
I can check. real quick.
I have seen him come from different places.
Oh,
Yeah, you got your spreadsheet, you can come back. Oh, you're fine, you're fine.
okay.
Yeah, I work with jail, Your Honor.
Do you switch them around?
West Virginia, very much,
Yes, that's exactly. I've seen you.
I don't know.
Sometimes it wins stuff.
Yeah, I'm all.
So is Mr. Lambert housed in Gallia or in?
Regional.
Yeah, Scott, he is in regional, even though he has Gallia on his clothes. Well, everybody's just share.
Training was the only one we bought it from value.
Okay, but his shirt, Mr. Lambert's shirt had Gallia.
They all,
What
they all wear orange.
Yes, that's right. All right, Ms. Hinman was on the stand, so come back up. And my notes say that you would ask for the support was 2,000 a month. She said yes, paid by the administration, and she said yes, and that's where we stopped.
All right. Okay. So Ms. Hinman, how are you being paid by Mr. Hinman right now?
Through the cash app.
And so you both have exchanged the information so that you can share finances that way? Okay. And you have shared with me, and I've shared with the court, a copy of the records that you have from Cash App.
And for the record, I have pulled your exhibit 4 back on the screen. So you need to reference.
And I would direct you to look, and it's on your screen there in front of you. Do you see that right there?
Yes.
And can you tell us what it is?
Those are the payments that, Joshua Hagman has paid to me.
All right, and is that, it looks like for this year,
I guess,
okay, or at least several months, it looks like.
yes.
Okay. And so does that record show that Mr. Hinman, paid anything in May?
No, it does not.
And, I don't know if yours goes back that far, it looks like that's this exhibit, but Mr. Hinman, did you happen to see his exhibit?
I can show
And you
whatever
can
he
show that
has.
as well. There you go. Does that look familiar to you?
Yes,
Okay, does that also look like an exhibit from Cash App?
yes,
Okay, and once again, it doesn't show that you received any payment in February, is that right?
correct.
Okay. So there are at least 2 months this year that there were no payments made.
Correct.
Okay, now later on in June, Mr. Hinman did pay 2,000. And I know his testimony's been that it was for the month of May.
Correct.
Okay, but you didn't get anything until June.
Correct.
Okay. And has this caused you financial problems?
Yes.
Okay, what kind of problems has it caused you?
I have, my own rent to pay. I have a contract, to pay rent. For my car, car insurance, anything that goes along with, living in a home, electric, gas, water, trash. And, like, and to eat,
Okay, okay. And you do work, right?
yes,
Okay, where is it you work?
Hobby Lobby,
Hobby Lobby, okay. But do you make enough from your job at Hobby Lobby to pay all of your bills?
no,
So you rely on this spousal support to help you make, is that right?
yes,
All right, and, on the months that you didn't receive any money, what did you do?
had to borrow money,
And so you're in a position where you're having to pay back
yes,
someone for the
Yes.
money that you didn't receive,
yes,
and that's caused you some problems.
yes,
Okay, and does that cause you to be stressed?
stressed, anxious,
Okay, and you had to hire an attorney, me, to be able to help you to get this thing sorted out, is that right?
yes,
Okay, and you don't want to go to court, I don't think, do you?
no,
Okay, so you'd like to just sort this out and be done?
yes.
Okay, so what do you feel is a reasonable situation, in terms of these payments? What would you like to want to do?
If they could just be, automatically taken out of Josh Hillman's, check. To be directly paid to me, and then I would at least have a time that I knew that that money was going to come in. That I can make arrangement prior payment.
Okay, and I know, I was looking at the court order from July 29th of this year, and I noticed on page 7 of that document.
I pulled it up here.
Thank you, Robin. And I believe that, and I believe on the second paragraph, can you see the second paragraph? There's a sentence that starts with the word defendant. Can you read that?
The defendant shall keep the marital home, is that what you're asking?
No, it's.
See where my cursor is?
Defendant shall set up automatic withholdings from his bank account so that the DJFS CSEA receives payment by the last day of each month.
Okay, so do think that if something's set up automatically, that might help?
Yes,
Okay. So you just want that to be part of what happens?
yes.
Okay. But do you feel like there should be a consequence to not having made these payments?
Yes, cause I still have to pay back from what I had to owe for February and May that I did not receive payment. Okay, unfortunately.
Okay, and so you want the court to find Mr. Hinman in contempt of court?
Yes.
Okay. And you've had other concerns that are stressing you out about this, divorce situation with you and your ex-husband, is that right?
Yes,
Okay, and that includes selling your property?
yes, I've been getting, notices from the bank. And also knowing that, the house is currently not on the market as of, June 1st.
Okay, so those are both worries for you?
Very much. So.
Okay, so you're hoping that maybe now this has been drawn to Mr. Hinman's attention, they'll be corrected?
Yes.
Okay. And Mr. Hinman, do you know how far behind they were at one point with the mortgage?
3 months.
Okay, but it's now been caught up, is that right?
That's what I believe.
Okay, do you know when that was done?
I believe it was last week.
Okay,
Dates.
okay.
Right now, it's not behind, it was behind, but now it's been to your,
Correct. It's been cut up.
So those are things that are worrying to you that are continuing to come up from time to time.
Yes.
So you'd like to sell your house and split the proceeds?
Yes.
Okay, and pay whatever debts that are supposed to be paid?
Yes.
Okay. Right. Thank you.
okay, you may ask questions now, Mr. Hinman. Cross-examination, just one at a time, and don't try to answer until he finishes the question. Yeah, okay, go ahead.
Yeah, you stated that you were. Or clearly you were not paid till the second
Of what month?
of, the 2nd of June for May.
But do you understand his question?
Yes, at that time I had assumed it was June.
Did you receive 2 payments in the month of June?
Yes.
So. Do you understand that the first one was for May?
There was no record or note in there saying that it was for May, since May had already passed and I already had made payments. to pay.
Okay, so would any rational or logical person understand that if you received 2 payments in the month of June, one on the 2nd, one on the 30th, that May one might have been a day late. 2 days.
Again, when I got the first payment in June, I thought it was for June. So I paid my June payments that I needed to pay.
Okay, so. When you received the second payment in June, were you able to catch up on your bills from May that you did not pay?
No, because I still had to pay back for previous ones.
When you pay your rent. In on June 1st, are you given any kind of leeway, any kind of grace period?
Not that I know of, no, I pay on the first, so.
Is it standard for most people to have their direct deposit hit when the bank just decides to put it on, like, let's say it's a weekend? Or how about more clear, we have Los Angeles Farmers Credit Union for our retirement, correct? Okay. My bank's in Los Angeles. They have the weirdest hours you've ever seen, but when it's a weekend, I don't get paid Friday or Saturday. It's sometimes safe to say that my direct deposit may hit on Thursday or Friday, some days it may hit on Monday or Tuesday.
So as far as I can remember from our 20-year marriage, is when it was fall on a weekend, you would get a payment prior to the weekend.
Has it ever happened where I don't get paid on that side?
Not that I recall.
Okay. Okay, so as far as working, you work part-time at Hobby Lobby?
Yeah. Yeah.
Okay. Are you capable of working anywhere else? For income, since you're so hard to make.
I'm sure I could probably apply anywhere.
Did I pay for, roughly the neighborhood of $4,000 or $5,000 for you to go to the bottom school roughly a year and a half, 2 years ago?
It was $2,000 last time.
Okay. And then the cost of getting there, all of that, correct?
Yeah.
There was it, okay, so was it free for you to travel to Columbus 2 to 3 days a week? to
No.
go to Fulani school? Okay, so it costs money. Is that correct? It costs money to go there?
Yes.
Okay. So is it safe to say $2,000 to $3,000 to $4,000 is it cost you to go to Fulani school?
Your Honor, I think we're getting a field here.
We've already talked about, it. I knew she completed the full file.
Okay.
So we don't have to, yeah, I knew she did
So
that.
my question is, so you can be a phlebotomist right now, right?
Yes.
Okay. But you choose to, how do you want part-time?
I have a lot of court dates,
Oh.
that I have been attending. Working at Hobby Lobby allows me to have a flexible, time that I can make arrangements to be here. Whereas phlebotomy would not allow that.
What causes you to work in court?
Being divorced from me.
Okay. How about this?
I know she has a felony pending. Deborah will take judicial notice of that. I'm aware of that.
Okay.
Because it's pending in this court and I've heard with her on that too. So if that's what you're getting at, I know that.
And I was gonna say, in Your Honor, I would object to any line of questioning in that area because that's not relevant. to what
Well,
we're
but she testified that part of the reason she might be arguably voluntarily underemployed is because of her responsibilities to appear in court. And I realize that it's not just this case, although there have been a lot of, in this case, it's also a felony case.
Yes.
So I'm aware of that.
They stated that you had to pay, Ms. Bunce. What caused you to hire Mrs. Bunce as your attorney?
To divorce him.
Okay. Prior to that, would you hire Mrs. Bunce for?
I'm not sure what the question means.
Okay, were you not?
She's my divorce lawyer. So that's what she's been hired for.
Okay, I think you got a follow-up question.
Did you hire Ms. Bunce to defend you or represent you in court on a domestic violence charge, which then was pled down to a simple that?
Your Honor, I would object. He's going into areas that have nothing to do with this.
Okay.
It's
Well, we haven't, that's gonna be sustained. You haven't presented anything, of course, about cost of representation or anything, and that would have been long ago. Well, I mean, not long ago, but would have been before the divorce. And so we're past that point right now where we're dealing with the post-divorce spousal support. in the house.
Is that I'm expected to pay this, right? So she's getting at is it costs her a lot of money to go to court and all this, but all those fees, I'm expected to pay.
Nobody, she's not asked for you to pay. I mean, she put that in the motion, but she's not got any witnesses or anything on that.
I'm just saying this, so I'm just trying to.
At such time as she has anybody where she's asking for the attorney fees beyond the base of the pleading, then I'd let you get into that.
Okay, the house is not on the market, correct?
Correct.
Could we have sold the house already?
Yes.
Is there an investor going to purchase the house right now?
There are lots of investors out there that will pay the absolute bare minimum. And if, I think I recall on the original divorce papers as well as this last paper, the house is to be on the market.
Why is the house not on the market?
Okay, well, I had reached back out to Amy Jackson to put it on the market, and she said absolutely not. I had also reached out to the, prior real estate agent that said that he would be interested. But with, his conversation with you and the state of the home, he said absolutely not.
Okay, so it's your belief that I should go spend money to fix the bathroom in the house?
I do not live at the residence, and have not for a year.
Okay.
I live in another state, and I cannot do anything with the property myself.
Okay,
Just answer his question. So do you think he should spend money getting the bathroom fixed? That's the question.
Yes, I mean, if you want, if we can get top dollar, or don't fix it, which is fine, but it still needs to be on the market, because I believe someone would come in and see the potential and still want to purchase it.
so it's your feeling, I should spend the money that we're barely struggling to survive with right now. I should go spend that money on fixing the house to make sure that you get top dollar to the house.
I think that it just needs to be put on the market.
Correct.
So I don't think that you need to spend
Okay.
your money to have anything fixed, but put it on the market. My answer.
Have I contacted your lawyer multiple times on trying to sell the house?
About the investor, yes.
Have you had your lawyer reach out to me about putting the house back on the market? Any shape?
Yes.
I've got just zero correspondence about that. Okay. Multiple times I've asked her to put the house. That she's showing me multiple emails about saying, let's sell it to this investor for 80% of what we get selling it. Like,
So it's that question, or are you
have
making
I
yourself?
done that? Have I made that
You
statement?
have. Yes, you have asked my lawyer to reach out to me about the investor.
Okay, so the house could be sold already.
I mean, you put on the market. Not through an investor to where we would not be making any money to, we'd have to pay still other payments like, back property taxes, things like that.
Okay, so then it's your position that I should work more, pay more things in order for you to get
I'm
time.
not sure if you would need to work more. I'm not sure. I can't answer.
How do you believe that situation would rectify?
Pardon me?
How do you believe that situation would be rectified?
As far as putting the house on the market?
As far as fixing all the issues with the house, how would that be?
She's saying she's not asking you to do that. Now, if I understood her correctly,
Okay.
she's saying, I just think it needs listed with the realtor and sold.
Okay.
Because I hope that, she understands, oh, there's so much money there to do things, exactly what you're pointing out. And then at least getting it on the market and having interest stirred up would be.
And I would love to get the house sold.
So
I'll live there.
why is it not listed with anybody now? I know you said Amy said she didn't want it back. Who else have you checked with? Either one of you?
I do have, two realtors here, Exit Bend Realty. Marion Duval.
So have you reached out to either one of them?
Yes.
Okay, and have they brought in potential contracts for anybody to sign?
No, Your Honor, there's only so much that I can do on my end as far as, telling them the situation of the home. I can't make appointments for them to come and look at the home.
Right, but do they have his phone number? Did you give them his contact? Info?
No.
Do you have any objection to having other realtors?
No.
Listing it.
I love the house also, I don't want to.
So, have you tried to get any other, where are those from? Those two?
Ohio.
Well, it's a big
Oh, I'm
state.
sorry.
Okay, so they're from Washington County?
Belpre, I'm not sure the county, no, but Belpre, Ohio.
Okay, so have your attorney write down that information to give him today. Just get it listed, someone that'll list it. And in our community, there would be, you already had Amy. There would also be Cleveland Realty, and there would be Wiseman Realty. They have an office across the street. Is there anyone else in our county really? There's lots in Athens and Washington,
It's rising. The house comes at great cost to me, right?
right? So it needs to be sold.
I'm just paying for everything.
So
And I just. and every
either
time-
one of you have the opportunity, if you want to, and I might look at it very favorably to ask that the house be sold on the courthouse steps to the highest bidder. And there's a process to go, but it costs the money too. And so that would be the alternative, because I understand both your positions that you are still paying for everything in the meantime, but you're paying a lot less spousal support until it's sold than you agreed to do in your original divorce. So you have to keep that in mind. And from your perspective, you're sitting and waiting for it to be sold to have no control over it. So both, if you file a motion asking to be sold on the courthouse steps, that could happen. Now, I think that's not necessarily in your best financial interest, but that's the only alternative this court would have. If you can't figure it out and work together through your attorney or attorneys, then I can order it appraised and sold on the courthouse steps, and you may get enough to pay your mortgage, because nobody's gonna want to buy it with a mortgage still attached to it, but I don't know if you get anything beyond that. So that's an alternative. Unless somebody can think of something else, and I would certainly listen to you if you had another suggestion. All right, any other questions for her, Mr. Henman? Any redirect?
Yes, Sean. So, Ms. Hendon, there are a lot of expenses, I think, that are gonna have to come out of any sale that you guys do on the property, is that right?
Yes,
And that includes your property taxes.
yes,
Okay, so I think you were recently made aware of the state of the property tax.
yes.
Can you tell us about that?
They are, they haven't been paid since 2021, I believe. Maybe 2022. I don't have that paperwork in front of me, but I think that, I have given it to you or your assistant.
Okay.
That the amount due right now is over $9,000 in past property taxes. So it's nine thousand.
Okay, this is not looking an argument. I heard him say something that he shouldn't have said anything. He can ask you questions on recross, but don't bicker back and forth with him. Thank you.
And you don't really know whether any of the other debts that were ordered by the court have been paid.
I do not.
Okay, so I know there was quite a list of different things that would need to be also make sure that they were paid before you or Mr. Hinman could receive any
Yes.
money as well.
Yes,
Okay. And it was part of the court order that Mr. Hinman was gonna pay those payments.
yes,
Okay, but when it comes to the taxes, at the very least, you know that he's not paid that.
correct.
Okay,
Sounds like it wasn't paid when they were together either.
I'm sorry.
It sounds as if it was not paid when they were together either.
Right. Yeah, but that they were not the same as what they've been since you separated.
Correct.
Okay.
If it's been a year.
Okay. And the sad and unfortunate thing that I know the court sees quite often here more recently with foreclosures by the treasurer's office is the fact that the interest and penalties continue to compound.
Yeah.
So it's worse and worse, doesn't it?
Yes,
Okay, so you don't want that to be even worse situation? Okay. And so you have talked to, you mentioned one realtor. Was there another realtor?
yes, it was, Wiseman Realty,
Okay, that's just right across the street here.
and, their name is Sunny,
Sunny.
and I have phone numbers for both.
Okay, all right. Well, we can provide those to you.
So that since it's right across the street, everybody agreeable to just at least get it listed with Wiseman? You can go in separately and sign. Do you know that's across Mulberry, which is the street here? I don't know if they're have regular office hours or not, but you can go in separately and sign a listing. That's done. Do that right away.
That sound good?
Yes,
All right, great.
Yes, sir. So can we revisit the whole selling it to the investor and just getting it done?
You have to, I'm not gonna be involved in any of your negotiations.
I guess here's my bottom line. So you talked about selling stuff. I've watched things happen. On Facebook, you've watched, and I've seen the auctions and stuff. It works on the house for now. I think they,
Or sometimes they're getting a lot more. The other day, there was one that went for substantially more than it
I guess
was.
we're not gonna get through it now.
So yeah, I'm not gonna get involved in you negotiating with, you have an offer, and if it's in writing, make sure that you exchange it with your wife's counsel in a documented way so you can verify, like by email,
Right.
return receipts that information has been relayed, but I'm not gonna tell you, either one of you have to do that. Because if you can't get together enough to sell the house, then the alternative is gonna be sell on the courthouse steps. I cannot and will not get involved in mediating or negotiating. We've been through that.
Trying to find.
Okay, then you need to talk to her attorney and have documentation of exactly when you did talk to her and what you talked about. Anything else?
And so you, are wanting the court then to make part of the orders from today's hearing, that there'll be additional, that the amount that's owed extra is how much that you're saying was not paid,
For,
spousal support,
Catch up the arrears.
the arrears amount.
so since the last, judgment was December, so it would be 2,000.
$2,000, okay. All right, and there's also though been two situations where nothing was paid for each of those months, is that right?
Correct.
Okay. And so do you believe that then puts Mr. Hinman in contempt of court?
I would believe so.
Okay, because there was a court order and he did not comply.
Correct.
And you want the court to give him all the penalties that are possible for a contempt of court?
Yes.
And that includes him paying your attorney fees, is that right? Okay. Now, do you want to have a separate hearing on the issue of payment of attorney fees, or do you have the information today that you can provide?
I think I may need an extra day. Because I myself am not sure of all of those
Okay.
attorney fees.
Do you have some authority that says we can delay that? I mean,
Well, Your Honor, I think the court has to first find that
Yeah,
Mr.
contempt.
Hinman is in contempt of court before we could even ask for any kind of orders in the first place.
Okay.
And so I think that's part of it, is that since there's been some question about whether, contempt is the issue or not, that's what we want to address first and foremost. I mean, ultimately, Ms. Hinman, you just want to get paid regularly, is that right?
Yes, that's all I'm asking is just for what the court had ordered.
Okay, you're not asking for anything
No.
extra,
No,
and you're asking for what originally Mr. Hinman agreed to do, is
Yeah.
that right?
yes,
Okay.
and certainly we hoped when that was addressed in the last entry that we've referred to by setting it up through the Child Support Enforcement Agency, through the Department of Job and Family Services, although I did get him to September to do that.
yes.
The idea was that would solve that issue. It's be
And you-
held from a bank account by the end of each month.
You went to the Job and Family Services Child Support Enforcement Agency, is that right?
Yes, I did.
Okay, and did you fill out whatever paperwork they needed to
Yeah.
start the process?
Yes, I did.
Okay.
And you'll need to do likewise, Mr. Henley. Anything else?
I have nothing for.
Any recross? Go ahead and have a seat, ma'am. Now, Mr. Hemmons, your opportunity to talk about and testify those things that I know you were trying to get out when you were being asked questions, but it has to be done in an orderly manner. So, I may have jumped the gun. Do you have other witnesses first?
No,
Okay, so then it would be your side of the case. If you want to testify, you don't have to, but if you want to, now's the time. If you want to call any witnesses, you can call them now.
Yeah, all the same as I did last time, my kids validated. But actually, we're having a hard time making it, but that's not gonna make any difference. Sure, I'm in contempt. I didn't mean, I don't know, I don't know how I missed it. I apologize, I thought I paid it. I honestly don't know. The paying late was just a matter of that's when I got the money in my account. The back taxes, we're behind. Like, I'm not lying behind it. I don't have enough money to pay for. I have my truck in the driveway right now, broken down for 8 months, I had to pay $4,000 to fix it, and it keeps adding up. I just paid twice, 2 months in a row, or I'm sorry, in the last 4 months, the state of California has decided that they audited my income from 2021 and 2022. And decided that we owed $1,800 and then $2,500. Well, guess what? They didn't just ask me like to pay it, they just took it out of my account. So things are a little, a little financially difficult. I'm sick, Last time I went to the doctor, he said, go home and enjoy your time with the family. I don't see how. Sure, if I'll make a attempt, I'll make an attempt. I made a mistake. No, I am behind, but I don't see how. Either putting me in jail for it, which would be great because I would lose my job. 'Cause I work for corrections now and in parole. They would just fire me. Financially, that'd be great. That would sure help Mrs. Hinman out some more money, right? Or let's find me because I'm already struggling enough to apply. I mean, can't even afford to buy clothes. I don't have any money. I get paid, I give her money. The rest of the money goes to debts that we incurred when we're together. But I get to pay all of it. And I know that I agreed to $3,500. Unfortunately, I sat in a room in mediation with Mrs. Bunce and some impartial mediator that were like, you just have to pay this. This is what it's gonna be. Doesn't matter what you do, you're gonna pay this amount. It's the best deal you're gonna get. Well, then, okay, great. That's just what I have to pay. Came in here and decided to just have this. There you go. I can't afford a lawyer. I understand I'm gonna have to pay for her lawyer now to basically give whatever they can out of me, but I can't afford one. I can't even afford to pay my bills, right? I retired 5 years ago with like $750,000 in assets and a house we and and now we're fighting over just getting, gosh, when it's all said and done, I hope we each get $60,000 or $70,000. I don't know. I just finding me is not gonna make it any better. It's gonna take that much more money. You can take the money out of my account. It just means that, at what point do I reach where I can't pay the power bill? Because I mean, for the winter time, the power bill is up to $900 a month. I mean, it just keeps adding up just more. Well, Josh, just pay some more money. Just give us some more money and be fine. But I can't. I don't have any more money. I can't work the overtime like I used to. I think you could probably tell by the way I look since I started coming in here and the way I look now, the way I talk, my health is really bad. I can't speak very well. But I still have to work every day. When I don't go to work, I don't get paid because I don't have vacation anymore because I haven't used my sick leave and vacation to go to the hospital. So just the way it was set up, I'm doing the best I can, pay what I can. Sure, I paid 2 days late. That was the best I could pull off. That was the best I could do. I still have all the cars that we had, that are whatever, broken down except for the one I drive to work. I still have all the bills we incurred. I still have all the credit cards we incurred, all the things that we bought in the house that we don't have anymore. We're at her house now. None of that went away, but I have to give her money and then somehow pay for all of it out of what I have. No, I don't know how. I get that the system doesn't care about my financial position, but I didn't cause the situation. Domestic violence for 20 years, which is irrelevant, I guess, but domestic violence 2 times in a row now are what caused the situation we're in. Somewhere along the way, I'm supposed to be the victim. My kids are supposed to be the victim. Thus far, I've seen nothing about being a victim, except for I just keep paying. I have one son that's mentally, this has destroyed him. So I take time off to go be with him or help him through whatever issues he has. I just, every time I turn around, it's give some more money, pay some more, do some more. I don't have any more. I'm paying the $2,000 a month. You're right, I paid it 2 days late. It's the best I could do. If I don't have it, I can't give it to her. So I don't have any other reason. I don't have a valid reason for not. I'm just telling you. I'm doing the best I can with what I have. I want to sell the house more than anybody, trust me. I didn't move here because I like it. I can't stay out here, family. Never liked them, never have, they've never liked me. Always never got them. Always despised me. I just don't really care one way. But I moved here and retired because that's where Tammy wanted to move with her family. So I have nothing here but my 2 kids. I would love to go back to Southern California. At least I can go make a decent living. But I don't even have the means right now to get my stuff back to Southern California. Because every bit of money I have is by the payment. I get, my $4,500 on the right around the first of the month for my retirement. That check is completely gone. Just I cash out her the $2,000 that night at like 3 a.m. to make sure she gets the money. That's what I can do it. And then by the next day, the account's already going to bank because everything is just auto withdrawal. So I would love to sell the house. I would like to sell the house to this investor company. If we lose $20,000, you know what? Cares, at least we're gone. I can leave, me and my kids can go to California and go like at least leave some bit of a life. I work at a high paying job here for corrections and I'm as high as I can get for the amount of time I have right now. And it's really not very much money though. Like I said, I'm doing my best. If you find me in contempt and I have to go to jail or something, well, that really be the nail in the coffin because then I'll lose my job right. Or find me. Like, cool, now I can go pay some more money so that I can't go pay the more money to here. Like it's just I'm stuck in this catch-22 where I just keep paying. I'm not getting ahead. And pretty soon I'm gonna die. It's coming. So I don't know. That's all I have to say.
Do you have any questions for him? I know you've already questioned him when you called him on, but not on the prospect.
From the statement, yeah. So when you say you don't have the money, so you haven't paid the taxes even when you were together with Miss Hinman, you didn't pay the property taxes back then?
We paid money when we had it, yes. I paid money when we had it. And there are payments made, and I can show you the breakdown, and I set up the payment plan with them. But when it comes to leaving the power on or having food or just enough gas to get to work, because I drive 90 miles each way to work every day. Awesome. To give them $547 a month on top of that, just guess which one you decide to do.
Is that for the property taxes?
That's the property tax, that's the thing.
Okay. So, what kind of income do you have?
We went over this on.
Yeah, that's way beyond the scope of this hearing. We've had that.
He's saying he doesn't have enough money, so I'm trying to figure out. So are you paying all, do you have any proof that you are paying all those bills? Because you're not paying the property taxes. How do we know you're paying any of those bills?
Well, how do you think the lights run? Give me a break.
Well, she's not at your house. Just answer the questions. Don't argue with her.
I'm asking.
Sure, I
like,
can go get my bank records at some point for you and break them in if you'd like. You want to go through them and see if you can find a way that I can make it, or give Tammy the house. Tell you what, give Tammy the house. I'll take $3,500 a month, and we'll leave and be gone if she can have everything. I don't care.
We're not renegotiating the divorce.
I'm
That's
just saying,
not
I'm
allowed
just-
to be done.
I got it.
And a part of this is because it's the agreement you guys made that now you're having a lot of difficulty living with. So you have this contempt that's pending about the spousal support. That's what we're talking about. Do you have any more questions about that?
So I know one of the first things you said was you admit that you are in contempt of court for not having paid. Is that right?
Yep.
Okay. And you are in a situation where you don't want to go to jail to lose your job.
I've explained all this thoroughly, I think.
Just answer.
Yes. I don't want to go to jail, lose the jobs I have, and that's the way I have.
That's correct. And you understand that you have to pay an extra $400 every month.
Only until he gets that
Until it's
$2,000.
paid, right, which is something.
It'll be
that-
5 months, yes.
Yes. And. I think that's all.
All right. Did you want to say anything else? There was a motion to show cause filed March 6, 2026, in which this issue was brought up. And so by that date, February hadn't been paid. We had multiple hearings after March on that contempt and all the other contempts. So that I'm gonna find is res judicata, and that's the only true contempt that they failed to pay in February, but then he, we went through all the hearings and, I mean, there, you just can't get blood out of a turnip. So, I mean, to me, that the February payment was dealt with when I made a decision to try to help fix things. I didn't put him in jail because to me, it doesn't make sense, or you're not gonna get anything if he goes to jail. So you have my decision that's in July, says no contempt, that dealt with February. The May payment 2 days late is not contemptible. So, I think you're gonna have to have some grace and some patience. Getting rid of the house is gonna help everybody. So listing it with the realtor today and or considering selling it at a reduced cost to get out from under it. And if you don't want to do that, I can't make you do it. But if one of you brings a motion saying we can't pay these payments anymore, sell it on the courthouse steps, I would probably do that. And you may get a lot more, or you may get enough to pay your mortgage and the real estate taxes and still have all these other things. I don't know, but coming back to court over and over again is not helping, because you're both missing work, not helping get things resolved in your life otherwise, not helping these two young men that are sitting back in the courtroom that have a place to live right now, but it sounds like a lot of financial hardship themselves. You're both having financial hardships because you can't take the income that you had together in a household and then live in two households and expect to have the same or the lifestyle, be able to pay the same bills. It just doesn't work. It's going to be a financial hardship for both of you to be adjusted to paying for two households. And it sounds like it has been quite an adjustment, and bills haven't got paid. Bills weren't getting paid real good when you were together because you have this significant arrears on your real estate taxes that you could have had it foreclosed on real estate delinquent taxes before this. So I think you just need to stop where you're at, be glad that, that's only 2,000 behind on the spousal support from February. And there's a way to cure that, which is that extra money each month and get that paid and get listed with an aggressive realtor that'll sell this property. And then you can go your separate ways.
You're right, and I don't know how this, I wouldn't even know how to present this, but. She talked about surgery, and that's why she had to put off for one of her things. I owe $5,994 for her using our health insurance, because now our health insurance charged me a premium, which is neat because it's through the state of West Virginia. Guess what? They're just gonna take it out of my check.
Well, you would have to file something on that because you were
I'm just saying,
divorced.
so-
How did she use your insurance after you were divorced?
I don't know.
You need to
Like-
file, you need to
Like-
challenge that.
Yeah.
Yeah, so, and
Well,
if,
it doesn't matter, they're gonna take
if,
it out of my check.
but
So my next-
did you use his insurance or did you think you did?
Yeah, yes, as far as I know, I was still insured under him. He assured me that I had insurance.
After the divorce?
Yes.
Since
Yeah.
we still live together, is that what?
No, it wouldn't matter. They're
Yeah,
divorced,
true.
she have the right for the Cobra notice. I don't know if she got that or didn't get it. So you guys have to work with the insurance companies and the medical providers for that.
Just my point is that, so next
That-
month when I get paid I probably make $2,400 every 2 weeks, but I only get about between 1,500 to 1,700 after I paid for all the insurance and all the other whatever special things that come out of it.
If they take it out,
$5,900, they're gonna take my check.
and if they do, you need to communicate about that and why, and at
Okay.
least create for the next contempt if they bring it, create.
You're saying, so how do I, and then these guys are gonna take the money out of my retirement account,
Whose guys?
but whatever, I have to sign up with this DJ.
They're not gonna take anything out of your retirement account.
Or they're gonna take it out of the bank account.
Right, and you can put your retirement and your paycheck in there. You're the one, like I say, you guys came to court with an agreement. And it's not getting renegotiated.
I
You
understand,
have,
but when they take that, right, when they start taking my entire paycheck to pay for this,
Mhm.
Right.
Then
where
you're,
does that money come from? Like, it's just.
I don't
So
know.
it's like, here we go.
It's not gonna come from anywhere. And so you're gonna have to get this house sold so you get past this, because I can't solve that. I can't
I know
create
you
more
can't
money
solve
for
what you're
you.
saying, so I'm gonna be attempt again. because-
Potentially, yeah, you potentially will be, potentially. But I'm just saying, get this house sold and so you're in, get on with your lives. Because you're just gonna have this revolving door in and out of here and everyone's just gonna be frustrated and spending a lot of money. That doesn't exist for either one of you. So go next door, get get it listed, before the weather changes. Get it, well, you maybe, and they sell a lot of property, that realtor firm sells a lot. So do you know where it is too, ma'am? Right across the street here, it's a little office.
Another question, what would be a reasonable expectation of time to have a response from the East Line? We're looking for months or? we're looking for
No, a
days?
week, but you need to email.
I've sent him messages the same day.
So messages or emails?
Emails.
Okay, then, okay, well,
Cause he asked me specifically about whether that she wanna buy from an
Yeah.
investor or sell to an investor.
and if the answer was no, the
And
answer
I
was no.
said, can you tell me more information? Can you
Mhm.
tell me names and people
Mhm.
and that kind of stuff?
Sure.
And
Did
that's
he?
when on Friday, I think, and I told her about it.
Oh, that was like this last Friday?
Yes,
I've been emailing since the last time.
Okay.
and we've.
Well,
just
you can,
talked back and forth.
there's no privilege between the two of you, so if you bring an action in, you can attach those communications.
Okay.
I can't, you can't know any communications between Miss Bunce and her client. Because your ex-wife has the right to that
Yeah.
privilege. But yeah, there just needs to be communication and knowing you're biting off your nose to spite your face. If there isn't, the quicker you guys can have that house sold and be going your separate ways, the better. We can't make anybody buy it though, so if to resort to the courthouse steps, we'll do that. And you have to consider if there are investors, that means a little less money, consider it because it's not getting more valuable every day. It sits there with not the attention that it needs. Because if there's not many, and I think Tammy was saying, yeah, I agree, you probably don't have money to fix it, let's just list it. I mean, that was a very reasonable thing for her to say, instead of saying, yeah, you need to spend more money that you don't have. She said, just get it listed. And that's what you need to do and not, I can't believe it wasn't listed June, July, and so far in August. It has to be listed or somebody's gonna need to move to sell it on the courthouse steps. All right, any other questions? Go across the street, don't go together, go across the street. Have her go first because she lives out of town and you guys can maybe go this afternoon. All right, James, you ready on some of yours?
Yes.
Hey, which one of yours are we on now? Gibbs, okay. What was that? Waving to the ladies in the back,
Stupid way.
your stupid way. No.
Yes. And, drive through the neighborhood, they talk over this. Email, there's, we need monthly.
I left the forms for the inmates to fill out
Mhm.
and two of them did not fill in numbers.
Well.
One of them is the Anderson, which I think we went over that last time he was in the, he's homeless.
Yes, so you just put the J. Yeah, but we have, I want to get something from it under us, so. Is it State versus Gibbs?
Yep. Said that, right? Wasn't on record. Just on YouTube. You call me anything to that.
Oh, maybe, oh my goodness, that's just, I'm sure you're.
It was with the law song.
We got Gibbs. Do you need Gibbs here? I thought somebody said.
We got a
we need-
couple motions, I think it's.
Okay, so yeah, we need Gibbs.
Gibbs,
So he's not in custody.
Oh, he's not in custody? Okay. So we just need Andrea and Mr. Gibbs, but he's not in custody.
Huh? I just said I'm going to file an audit. You haven't filed it yet.
Okay, so Gibbs is gonna be an Ollie?
Yes.
Oh, he just has one case, right?
Yes.
First one of 2025, so probably don't need him in here, but you'll be getting that. Do you want him in here for open record to come back at a later date? Put that in Ollie?
No, we discussed all of this before we came up.
Okay, then we won't. And you'll waive the right to have it not in open court with him, okay, I'll watch for that. And what about any others then?
We don't need to talk about it today, but on Wolf, there's gonna be an audit on that as well.
Okay. Okay. And then, that takes care of them all until this afternoon on, do you have any of them this afternoon, Scott?
Yeah.
Okay, we have Wiseman all afternoon. All right, well, speaking of all afternoon, it is 12:52. Sorry. It's just the way today's schedule is. So as soon as you get Mr. Wiseman here, it looks like we have, again, some pre-trials and we have any.
Did you take care of, Wolf?
Yeah.
Yeah, that's gonna be in.
Wolf and Bank.
I'm at the fairground.
Oh, Athens County Fair.
Going pigs all morning.
Oh, how fun. All right, I think the only substantive motion that I saw was the one for 3 o'clock. Okay, so other than that, I'll let you guys work and I'll come back out on record when, and if you're ready to put any on record. Thanks.
No, I do want to not honest. I think there should be a not. We only submit our stuff to TV, they always ask us what was the result. It's, I mean, what if you,
The client gives a prison for like 10 years, yeah.
that should happen all the time.
No, if you get
We're off this
bonus for doing good, then you should, you know, there's something.
Yeah, I can't change facts. That's not shit bullshit. It's personal, whatever.
I don't know, 8 years. Actually, I mean, in my forms.
Do that.
See ya.
What channel we have next week?
Next week, we have 2 of it's just scheduled, Lacey Kennedy. It's Conley case.
What kind of case call?
Bad news. Yeah, sucks cases.
You guys have a good day.
Yeah, I'm very.
I'll see you Wednesday.
Might not see me.
Wednesday.
Once I saw earlier, I didn't hear what this. Yeah. Already there.
Almost.
Yeah, good one.
I love it.
So you two, so.
Whole Christmas video.
We need to fix that.
I did it because I understood how the thing was gonna be. So I actually. You should let that thing. If you want to.
Very firm option. We could fall in today.
Yeah, probably.
See. See if the or knowledge for both. Yeah, we got 2 dozen cases. I saw that and I thought, sure, that. I don't know. It's not. I know.
Oh.
Tower of the DLC. I'm in for it. So. Yeah, and then the luggage. Yeah, community sessions.
Oh, boy. What? What was that? What was that?
It's just the thing, they can, about 24 cases today.
Um, and maybe one more because Rhinestone needs a ring.
Yes, so I did put that on the offer though.
Yes. Yeah, he's not gonna go anywhere. So these are all set for September 8th. Then we'll just need to arrange on it's.
Oh.
I got a loss there. So. Are we currently being broadcast?
I think so.
Okay, cool.
I walked in this morning, I dropped a D bag right off of that. On YouTube. Oh, it's to his face though. Wasn't behind his back.
Okay, all right, fair enough. Well, let's start with the easy ones then, other than Rhinestone. Eric Mays. You gave me an offer. He's in the hallway. I think you gave me an offer. Oh, yeah, he's in the hallway. I just need to keep his dates. He's an initial pre-trial.
It was fun.
So I can get him out of here. As long as that's okay with you guys.
Yeah.
Okay. Thomas Anderson, I've spoken to.
That's all right. He's got a lot.
So that one, maybe just given where it is, we can go on the record, bring him in, and I can just say I've requested discovery. I think you responded a few days ago, but I haven't received it from them yet. I think that's
August 6th.
yeah. And I think I took that one over for Denise.
Yes.
So I just want to put that one on the record to note that. And then perhaps similarly with Kevin Dalton, I have spoken to him as well. And I filed a motion to modify his bond that I asked the court to consider today. And I took that one over for Denise as well. He is incarcerated.
Oh.
So I think if we could go on the record, I mean, I'm gonna ask Andrea if it's okay with you to go ahead. Unless you're waiting on any victims to go on the record for Stone, Anderson, and Dalton.
Shall it's like I'm looking to here on Stone, Henderson, or Dalton.
But I think all
I do that here in a few months.
I'll get Mays out of it.
Big thing is, I'll probably reduce like inside. That's what my son on. A good carnival. Like a week of, I was, I said. It's not until these, I didn't use. Range all funds, so the process. Already, did you already?
I did,
Oh.
actually, yeah, I just did. So they said, I don't know if you guys have any information, Robert Forla. I thought he was in jail as well, but maybe he's at a different jail, because they told me at the back he's not incarcerated. I thought that was odd, because I thought his bond was revoked. Maybe I'm just like misunderstanding.
Let's see down on our list.
You-
Yeah.
I guess maybe I just took it that, because the motion to revoke his bond was filed based on a positive screen, so I just assumed he had been taken into custody. Maybe that's just a bad assumption of mine.
Was that one that was filed last week?
Yeah.
I think that was because he failed a drug screen, and so they were giving him a second chance, but he failed to report thereafter.
Oh, okay.
But he's here today, so
No, he's not. I just thought he would, I thought he was on our schedule for today. I thought,
he is on schedule
Okay.
for 1:45.
and I asked in the back if he was there, like, and they all told me he was not incarcerated. So I was just confused by that. I just assumed he was incarcerated. So maybe he's just not here, and that won't be a big deal.
I'm surprised those didn't show up.
Around the whole.
Yeah, she was. That was my impression.
13. There you go. Yeah. I don't know. Up to these guys, and Mr. Stone would be okay with me.
That's fine.
It's what you said for the judge. You remember it? Oh, I was part of the right. No, I haven't. Did you mark that? Okay. All rise, please.
Thank you. Please be seated. Come on, Libby, place. I guess I can take down the post-divorce stuff here. Anybody wants to see that? There you go. Mr. Stone, right? Yeah.
Yes, sir.
And he has a new case too, Judge, that we need to arraign him on.
Oh, okay, so I have case number 26 CR 014 and 26 CR 080, and then there's a new one,
Well, and then you should also have
Oh.
26 CR 082.
and 26 CR 082.
Yep, and then his new case is 26 CR 95.
095. Okay, I need to, is that already on the schedule for an arraignment
No.
today?
No,
So I need to add that.
yeah, you had, I think it was,
I had the other three.
indictment. Or maybe not, I don't know.
It's my event, Susan. Yeah.
Home straight for you guys, just to get everything else filled out. Is that rain I hear outside? Hail? Or just rain? I think I'm ready.
We're on record.
We are on record in the Meigs Common Pleas Court. And State versus Stone, cases number 26 CR 014, 26 CR 080, 26 CR 082, all scheduled today for a variety of pretrials and statuses. And also we're going to be on record on a new indictment in 26 CR 095. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Ron Gaishman.
Okay, and you provided a written address, phone number, and email on a piece of paper before you came in today?
Yes.
Okay, with that then, counsel, for the
Thank you, Your Honor.
defense
Frank Wiseman, attorney for Mr. Stone.
and for the state?
Yes, sir. I'm James Stanley, Meigs Common prosecutor here, we have to say, Ohio.
Okay, and out of these 4 cases, are there victims in any? And were victims in each case notified? Are victims present? Okay, just watching, okay. And are we expecting anyone else that may be running behind or anything? All right, and let's go ahead and get the arraignment done on the new charge. Did he receive a copy of that indictment?
Your Honor, he has not received a well, did you receive a copy? Okay, he did, but we reviewed it together anyway. But
Okay.
yes, he has received a copy of it.
Was it more than 24 hours ago?
It was, Your Honor. We would further waive the reading of that indictment as well as all penalties and rights associated therewith. We would further enter a not guilty plea to the sole count of the indictment, which appears to be a felony of the 3rd degree.
Yes, having weapons under disability felony, the 3rd degree. And so you understand your attorney's asking to waive the right to have the indictment read to you, your rights read to you, your the potential penalties read to you, and that you want to waive those. Okay, and a not guilty plea is entered on your behalf. You do not need to have an attorney to assist you through the process. Mr. Wiseman has been appointed on your other 3 cases, but not yet on this one. Do you want him appointed on this case as well?
Yes.
Okay, you have to fill out a separate piece of paper for a counsel appointment if you haven't already, because each case should have its own. But we're going to assume you're still eligible and we'll appoint Mr. Wiseman in that case. Also, you have the right to have a reasonable bond set in that case. What's the state's position on bond in case number 26 CR 095?
Say recommend hour long, please.
Defense?
We would leave bond at the discretion of the court.
Okay, no, our bond will be granted in this case, since there's especially no individual victims or anything. And the OR bond, because the underlying newest charge is also a felony, it's very significant. If you're able to get out because the other cases are resolved, or for whatever reason you're out, you must realize that if you sign the bond to get out and then you don't show up for any scheduled hearings, you could be charged with an additional serious felony. Do you understand that? Also, you cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. Your firearms disqualified. You cannot own, possess, acquire, use, or attempt to do any of those with firearms, and can't get any other trouble. No contact with law enforcement resulting in charges or arrest. Do you have any questions about the conditions of bond? Well, the other condition is there. This one doesn't have an individual victim, so he's already got his conditions on it. Do you have any questions about the bond? All right, with that, then let's not schedule hearings till I find out what's going on in the other three cases, and then, because we may have to do some correlating if they're working on a global resolution. Is that what you're doing?
Your Honor, we attempted to do so. However, I do not believe that at least at this point is not fruitful. It appears as though after speaking with my client, the intention would be to proceed to trial on the three pending matters, which again are the 26-014, 8-0, as well as 8-2 at this time.
Which ones again? 26 CR
1-4,
and
then there's 8-0.
yes, and
And then
8-2.
8-2.
All three of those. Okay,
Yes,
so you just said two of the, okay. And 8-2. And when are we scheduled?
I believe they are all scheduled for September 8th.
And are we good to go on that date? Any last minute obstacles dealing with discovery or other issues?
Not that I'm aware of.
Your Honor, I've reviewed discovery in all three of these cases, and I do not see any pending issues or discovery things that need to be addressed before the court.
Great. So I assume we've both double check, but I'm sure we have your summons for that date. Check it here. I do hear that rain. Yes, that is a Monday. She doesn't have, oh yes, she does have summons jurors, so she does. The other cases that are scheduled that day, I
It's a
assume.
Tuesday, Your Honor, just to.
Oh, I thought you said 8th. Oh, that is a Tuesday. I don't know why. Yeah, I'm so sorry.
Sorry, I didn't mean to interrupt.
No, I appreciate that. So you also have Fisher, but it is if he's not incarcerated, and
Mr. Fisher is incarcerated.
okay, it's scheduled that day as well. And Bergman and Mr. Stone. But we'll address that later.
Yes, we
Okay.
can address it later.
Okay, that's fine. So assuming we're going to proceed on September 8th, Tuesday, then I'd like to fit in something about a week before, or the Monday, a week and a day before, just to make sure there is anything last minute, that the exhibits all been uploaded to the case center, the jury instructions are ready, and so on. So if we could do-
Well, I was going to set the initial pretrial on the new case on August the 31st at 2. So do you just want to set a status in the other cases at that time?
Yeah,
Fine.
sounds perfect. So August 31st at 2 will be just a status on these three cases that you've been pending a while, and the initial pretrial for the case that you're just getting arraigned on, the firearms case. Okay. What time did you say?
2.
2. And then what dates do you want to go for a final pretrial, motion, and jury trial on the new case?
We can set a final pretrial and motions hearing for September the 21st at 1. And then a jury trial date of October the 27th at 8.
Those dates are going to be on an arraignment. If you'll get today, you also have to sign that bond on that new case today, and keep a copy of the arraignment entry. It has Mr. Wiseman's contact information, has your bond conditions. It has those dates all on the back page. So make sure you have both pages and get them in your calendar. Do you have any questions? Okay. Anything else from the state?
No, Your Honor, thank you.
Anything, defense counsel?
No, Your Honor.
All right, thanks.
Thank you. Thank you. Did they give you a pen?
Yeah.
095.
I'm sorry. When he gets,
So he is going to be out on an OR on one.
On
case,
this one
but
case.
the other cases, they're still passed on.
So he's not getting out today. Bless you.
Anything else?
Got Mr. Stone, who do you want next?
Oh, Mr. Anderson.
Mr. Anderson, okay. I think this is the first time you're meeting with him.
It
Because
is,
of the conflict.
yes, correct. There's not a lot to do. I just did want to go on the record.
Yes,
Some of
yes,
that.
I think that's good.
State versus Anderson.
We are on record in the Meigs County Common Pleas Court in State versus Anderson, 26 CR 059. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Anderson.
And you provided some information to the bailiff that he put on a form about where you could receive mail, correct?
Right.
Okay, and so we do already have that, and we have defense counsel. He's going to identify himself.
Thank you, Your Honor. Brett Wiseman, attorney for Mr. Anderson.
And for the state,
Yes, Your Honor, James Stanley, Meigs County Prosecuting Attorney, on behalf of the state of Ohio. Along with Assistant Prosecuting Attorney Abigail Wilkie.
and in this case, there would be a victim or victims. Was the victim notified? And is present, okay. With that, we are here for another initial pretrial, because if I remember correctly, Mr. Anderson had a previous attorney who had a conflict. And so now, Mr. Wiseman's just getting involved in the case, so you wanted to put things on the record that you're just now getting geared up, I suppose.
Yes, Your Honor. I was trying to pull it up online here and I think I finally got it. I just wanted to note that I did have the chance to speak with Mr. Anderson prior to going on the record. We did discuss the fact that Ms. Bunce previously represented him. She was able to get him his written discovery information. So assuming that what I received is what he had previously received, which I would imagine it is, he's already received a copy of everything. So we discussed all of that. We discussed that I had filed a notice of appearance as well as a demand for discovery just shortly after getting appointed. It appears as though the state responded to my discovery request on August 6th. So that about 4 days ago from today. So imagining that's probably in the mail getting to me. So as soon as I receive it, I'll obviously be reviewing it and speaking with him further. I believe that the dates, I would imagine, have been reset under my calendar. So I imagine there's probably no issue there. But at this time, that's kind of where we stand. I, again, was able to introduce myself to Mr. Anderson, explain all of this to him as to where we stand on discovery. He was able to converse back with me, and that's really the only update I have at this time.
Okay, and from the state's perspective, anything to address on the record?
I don't believe so.
Okay, Mr. Anderson, do you have any questions about what we're doing today? Okay, you understand you have a new attorney and he'll be communicating with you and getting things ready for the next hearing. The next hearing is what we call a final pretrial and a motions hearing if there are any motions pending. After that would be your jury trial. But in the meantime, Mr. Wiseman will be in touch with you as he communicates with the prosecutor.
Thank you.
You're welcome. If nothing else from the state or defense, we'll let you go back to the sheriff's office. Thanks.
Thank you, Your Honor. And then I have already spoken also with Mr. Dalton.
Do you want him
Go on
on?
the record?
Sure.
Please.
Yeah, that's fine. Dalton? Dalton?
State versus Dalton.
We are on record in Meigs County Common Pleas Court in State versus Dalton, case number 26 CR 076. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, state your name.
My name's Kevin Dalton.
Okay, and you provided your address in writing and your phone number and email. Okay, with that, counsel,
Thank you, Your Honor. Brett Wiseman, attorney for Mr. Dalton.
or for the state,
Yes, Your Honor. James Stanley, Meigs Common Prosecuting Attorney here about the state of Ohio, along with Assistant Prosecuting Attorney out here.
And given the charge, there would be a victim or victims. Was the victim notified? Is the victim present? Okay, and so she is actually on there. I don't have to wait or anything. Good to go. Okay, great. So this is our initial pretrial at this point, which is usually the first time you're really spending a lot of time doing some serious communication between you and your attorney and the state. And so I trust that's been able to happen today.
It has, Your Honor, yes.
Okay, what else did you want to put on the record?
Yes, Your Honor. I wanted to note, this is similar to the last case we had wherein I'm taking over for another attorney. Ms. Bunce likewise was appointed to represent Mr. Dalton, and it appears as though there was a conflict that arose at some point. So this is my initial meeting with him. I have requested discovery. I was just double checking to see if that's been responded to yet. But as soon as I got the case, I believe I filed for discovery, and doesn't appear as though yet it's been responded to, but I imagine that'll be forthcoming. It looks like I didn't get a demand filed until August 6th. So that's ongoing at this time. I did file a motion to modify bond though, Your Honor, if the court would entertain argument on that issue.
All right, and yes, we'll go ahead and address. I did think there was notice and a request that the victim be notified of that you were going to do that. What else did the state want to put on the record before that? Okay, then go ahead.
Thank you, Your Honor. The only thing, again, I previously took this case over. It appears as though Mr. Dalton has now been incarcerated since June 21st of 2026 on this case. I was appointed July 29 before that, June 16th. I was able to glean from the docket, it was June 21st, but he may have been arrested even a few days prior to that, June 16th. I was just asking the court to consider, again, an OR bond in this case. Again, it's a receiving stolen property violation of a protection order, lower level felony offenses. I did a quick search in Meigs County and did not see any prior felony convictions, though I don't have a CCH or anything in front of me. But due to the swap in attorneys, the low-level felony offense that he's charged with, and the fact that he's been incarcerated for a significant amount of time now since mid-June, I would ask the court to consider an OR bond.
All right, state's response to that request?
Yes, I say that's the court, so the bond as opposed to others.
And that was
I believe that was 50,000, so.
with 10%.
Yes.
Right, and did you talk to the victim about the position, or that's just the state's position?
Yes, we decided to contact the victim. The state's position is up for the bond, so.
Okay. All right, anything else?
I was just going to note, Your Honor, that I did double check with Mr. Dalton that the address he gave, the Albany, Ohio address is his address. It's in the court record. At least what he gave at the initial arraignment is an accurate address where he could stay. So again, any monitoring, things of that sort that the court would deem appropriate, we would ask for. I understand $5,000 is still a significant amount to come up with to be released, and then he just does not have it at this time. Thank you.
I'm gonna leave the bond where it was with that 10%, so that is $5,000, I realize, but it's a lot better than 50,000 with no 10%. But at this point, I'm gonna leave it the same, especially, you know, I take very seriously, of course, alleged violation of a protection order and that sort of victim-based charges, one of the reasons for keeping it for safety. All right, anything else we can, a date's okay we're on your calendar, as far as we know, dates are good. Because I think she switched.
If you switch them, I'm sure they are, Judge. I didn't look specifically, but if there's an issue, I'll address it.
Okay, I think it should be. Yeah, I think she wanted to keep him on a fast track in case they couldn't make bond and put it on your schedule.
Understood.
All right, do you have any questions at all, Mr. Dalton?
I guess I'll go back on 30th, right?
If that's your next hearing date, I don't remember without looking.
Well, they sent me a paper saying that this would be my court date today, would be the 30th.
Let's look at it here.
And then they come and got me this morning.
Here's as though I have the August 31st as the next hearing, and then a jury trial September 22nd.
So August 31st. So close.
I'm looking on court views.
Yeah,
So that's
okay.
what I have.
That was what the schedule was put on when we assigned you.
Okay.
Okay. Is that right? That is the schedule?
It looks like a few have been continued, so I would imagine these are the new dates.
Okay, that's what, okay. All right, anything else?
There you are.
Okay, anything else from the state?
Yeah.
All right, you can go back with the sheriff. Thanks.
Rick, do you have any more on the board?
Not at the very second. I mean, I still will, I'll need to meet with them. Okay.
All right,
Yeah.
what about
Yeah.
Meigs? Did you need a record on Meigs?
Mr. Mays, no, we did that by entry.
Okay,
He did it.
and then we're gonna need a Bergman or Thorla. We have Thorla too.
Mr. Thorla, I asked a few questions about that. Incarcerated. I kind of took it from the court's filings or the filings I received that maybe he was incarcerated, but it appears as though he is not.
And let me pull up. See what happens.
But Bergman, we probably could go address whenever. I know my client's in the hallway.
Okay, let me see if I can figure it out.
You say May's dates remain the same?
Yes.
And have you talked about Thorla?
Thorla, let's see what happened to his arraignment. Pulling it up.
So that was the one, Andrea. I got a couple notices that motion is
Okay, I thought you
bond
were
was
talking about.
revoked and
Okay.
so I took it that he was incarcerated based upon an alleged screen. But I think James said maybe they gave him another opportunity and then maybe he didn't appear, so he may not be incarcerated.
Okay.
I just took it that he probably was.
Alright, I'll look it up.
Thank you. Yeah, I issued a bench warrant on the 7th of August. And
Oh, I know.
let's see what happened. So I don't think we're gonna serve. He's not been served, has he, with his warrant? That's just the warrant. issued.
No, Jill.
So still looking for him.
No, the last thing is that we issued the bench warrant, so I don't have a return for him. So he is. What?
We just had the one case on Bergman.
Yeah. So who is this? Bergman's?
Yes, I believe. Yeah,
Is that okay to bring Mr. Bergman up?
Sure.
Okay.
State versus Bergman?
we are on record in the Meigs County Common Pleas Court in State versus Bergman, 26 CR 056. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please. And are you second, third, or, okay, so I knew that your father had the same name. And your address, phone number, and email have been provided in writing?
No,
Oh, wait a minute. Not today yet?
I don't have this one.
Okay, tell me one side.
So here's a piece of paper. I just want you to fill it out under oath so we have an accurate phone number, email, and address. You can wait till afterwards to listen to the proceedings, but I want that before you leave, if you will do that. And your counsel for the record
Thank you, Your Honor. Rick Wiseman, attorney for Mr. Bergman.
and for the state?
Yes, Your Honor, James Stanley, Meigs County Prosecuting Attorney here about the city of Ohio, Assistant Prosecuting Attorney at Gilbert.
And given the allegations, there would be a victim or victims. Is the victim notified?
Yes.
Is the victim present? Okay, so we're prepared to proceed. Today, we are scheduled as a
It was a final pre-trial.
final pretrial. I had to get down to that part. So a final pretrial, which means we're heading to a jury trial unless there's a resolution, right?
I just from the state's perspective, Mr. Wiseman provided the state with some, I guess, additional information that we need to investigate. So I think we're both wanting approximately 45 more days to do well.
So you're asking to move the date. What was the date that was scheduled?
Looks like the jury trial date was September 8th.
So you're asking to reschedule the jury trial another 45 or so days out, and we'll do a status before that though, so. That is sufficient time, Mr. Stanley,
believe
Mr.
so.
Wiseman?
That would be fine.
Okay,
Yes.
so let's schedule status and a jury trial date.
What about a jury trial date for October the 6th at 8?
October 6th at 8.
And then we can set. Do you just want to set a status for the Tuesday prior? Because the Monday prior is when we will be, or the judge will be out at the drug court participants. So can we do it by phone or Zoom on that Tuesday?
It's fine with me.
That's
Well, I'd like to have it if it's in
Okay.
person, but I don't know.
Well, that's a Tuesday, so it's up.
What day is it?
That'll be a Tuesday, September 29th.
But what about is the 28th not available?
Well,
Is
the
that Labor
28th,
Day?
that's the day that you're gonna be.
Oh, that's the drug court.
Yeah.
Yeah, thing, okay.
Is it possible, is there anything on the 21st? Could we do it the 2 weeks before that?
Yeah, we're gonna make it the 21st at 2:30 if you want a status. September 21st.
That sounds good. So status September 21st at 2:30, jury trial October 6th at 8 AM. Your attorney's writing down those dates for you. They'll also be on the entry that you'll sign today. The entry you'll be provided after I sign, I should say. You won't have to sign it, but you do have to fill out that paperwork. If you would do that, that would be great. Do you have any questions at all, Mr. Bergman?
Your Honor, I do have something just to raise.
Oh,
before if that's-
yes, go ahead.
It's nothing by the state. I just, wanted to put the court on notice. I filed a subpoena on July, or excuse me, I think it was, I need to look. It was sometime in July, for the audio of the hearing that occurred in this court in case number 25 DB 89, which would have been the CPO hearing, a DB CPO, I believe. I have been in communication with the court staff about how to get that to me and what the court may allow me to access. So I just wanted to, I guess, address that with the court and see if I would accept the audio, or if the court wants to order a transcript, I'm okay with that too. I imagine it's probably not terribly lengthy. There was just, from my understanding of looking at the record, there was an ex parte hearing. And then at the actual hearing itself, it was, the
Consent.
issue was agreed upon.
It's
So I
consent.
imagine there was not extensive testimony at that hearing.
Yeah.
But it would have been at the ex parte hearing. I would imagine that the alleged victim would have been the one who testified then. And I think, would like to hear and listen to that testimony.
I think under the rules of superintendents, we can make the audio available to council only to listen to. And obviously, if you wanted to be able to use it later, you'd have to order a transcript. They'd have any objection to that? That
That's
work for
fine,
you?
yes.
Okay. All right, anything else?
No, Your Honor, that's it.
All right, then you're excused to go. Thanks.
Should I fill this out here? Or take-
Yeah, well, you can fill it out there. It's fine. I don't know if we have somebody else coming in this very second, so if you want to do it, it's fine. I don't think I put on the record, Mr. Stone has to be fingerprinted and photographed on the entry, I believe, coming to that effect. Mr. Stone on his new case, did you get the fingerprint order? Yeah, but I failed to say that on the record to him. So Britt, if you're talking to him, I'm sure they probably have already done it since he's in custody, but.
Sure, he's getting front of right now.
Oh, okay, perfect. Perfect.
So are these is this the victim in Mr. Bergman's case? Okay, we'll make him stay here for a few minutes so they can't be accused of each following each other, so that's fine.
A bunch of people watching. I think. Citizen, just like they would, just.
Yeah, if you'll just stay here, we'll tell you when you can leave.
Okay.
That way there's.
That'll work. You touch it next. All right, you're welcome. I'll go back and speak with Mr. Conley.
Yes,
And Mr. Ficker,
okay.
and I don't know if Mr. Lill, or if he's incarcerated or. It's like a new one for me. OR bond. Oh, but he's serving a sentence out of county court until December, so he probably should.
Hopefully they brought him.
Which one's that?
Chase, Chase.
Chase Will?
Yeah.
He's back there.
I think it's Bill Chase. He's one of those that has.
Yeah.
Two first names.
Two last names, yeah. Speaking of which, I wonder how James Henry is.
I don't know.
I
I
said
haven't
that-
heard that name in a while.
I know, but I always think of that when I think of two
Actually,
names.
so about the address.
I would love to. Well, for right now through December, I know it's the,
Yeah.
what-
Hopefully, maybe he has a home address too.
Okay,
We-
right.
It's NA.
Can I? Huh? Do I? Oh, no.
There's a bunch of absconding warrant or absconding notices here.
Why does this Conley, he's got like two cases, but just say he's come back. On the schedule.
Because it has two different hearings, the status and it's a motion to.
Yeah.
Yeah, it's good, I mean, they say, well, status, if we file this motion, then we'll hear that motion, so you gotta put it in as a status and a motion. That's fine.
Hey, Jim, I could use a couple double A batteries. This mouse is acting as if it's.
Couple double A's.
Entries here on absconding.
Hmm. Oh, let me, I wiggled them around. Let me get this last one down and let you switch them.
I'll switch them when you're done.
And this one I'm having to look at a little bit. Here, you can go ahead and switch them. It's fine. Senna, you woke up. Hello, Senna Marie. Over there to visit Abby. She's in front. Oh, don't let she's that she was pulling that iPad accidentally. She got tangled in it somehow. Senna. Must be working because it changed my page. You shut out my, so it's working.
I'm turning stuff off.
Yeah, you are. Thank you.
One more another thing.
Yep, it's working now. Thank you very much.
Question.
No. It's trash. Take it home with. Oh, yeah. You can go in there and try to get the flowers. That's what we need. We need to get a dartboard for when the judge leaves. The 2.5 weeks.
Yeah, you're gonna have something to do.
If he's good to go. They can make it through security.
Yeah, we got a message that they've gone, so yeah, he's probably good to go.
How we didn't.
So Thorla is warrant out for him, right? That's what we said.
Oh, impressive. There's
Uh.
no warrant for this case.
You still talking to Britt about these other two, the last couple cases?
We talked about all of them probably.
Britt Rowland. He's just taking one of them back this time and it's in a,
No.
so.
We already found the warrant instance.
Okay.
Not all of them.
Right. Huh, but
Derek, did you deal with someone who used at the city law director?
I think so. The name doesn't sound familiar up there.
I remember we used to deal with him with meth labs. I did once. He's like me, one of the unfortunate ones that still have been seen. They imagine being made. Yeah. Probably done some zebra.
His attorney forms,
Yeah.
how they afford drugs and cigarettes.
I think, to the house or the green up. Okay, which is this the whole thing. So it's. Second, I said to the house or second. So, the year I should.
Yeah.
But. I hope I'm not, that's on the shoot.
Oh, I think I'm my car. The trial. Yep, yep, he is. Let me take them and I'll have them in my car, so I'll always have them. Okay. Chase will, you could just keep dates. Um. He is essentially unhoused. I'm gonna contact the council and someone and see if they can do an assessment regarding. If he gets released, he doesn't think he's being held by the county court, though I looked at the arraignment entry and it sounds like. I mean, he must be somehow, or else he would be released, but. For himself, he's like, listen, it's not actually good for me to be released because. I'm not gonna be able to find a way. So I'm gonna reach out to the TCC, if I can get him approved, then I'll contact you in court. But I said, I think you're serving a county court sentence, so I don't think so.
Yeah, yes, until December 20th.
See, I told him that, he was like, no, they dropped that.
He was, but Abby was there for us, so she could tell you more about it, but he's definitely serving.
Okay. Well, I was like, dude, I don't know why you're incarcerated, but we assume there's some reason. Okay. Well, keep dates on this one and go from there. We can go on record on Fisher and Alvin.
I believe that's it, yeah.
Circus wasn't too bad.
No,
Yeah.
this is calm, very calm.
I'll take that as my presence. Okay.
Here's
You know, I mean, I have very calm presence.
Yes, he told me to do that. We just had a civil case with Denise on a pro se defender, and that was painful.
You just had to sit through it.
Yeah. While I was working out, or trying to work out pieces of trauma.
Gotcha. Were you handling unprovoked chase the other day? Brooklyn chase?
Yeah, so he's
No,
Oh, I thought you did.
no, I'm just aware of.
Oh, okay, well, he didn't think he was still, he thought that case was dismissed. He didn't know he was serving a sentence. It's like me telling him he was, maybe Malcolm said it was a compensation. He was convinced that, he's like, no, that just got dropped.
What do you think it's in jail?
Yeah,
Well, he knew, I'm pretty sure he did one of those when he found over, meaning that it was dismissed at.
Oh.
And potentially, I don't remember. But he was sentenced on other cases.
he had no clue what I was talking about when I said, well, I said, I read your arraignment entry, it says you're in jail for December 20th. On a county court. Not that I know of. Listen. Mills? No. I don't know. Then we'll be ready with Conley right after it's scheduled at 3.
Thank you. Please be seated. Thanks. I think Jim went to get somebody. Libby, say hi and then come to your place. Not sure if she wants to. She wants to visit. Good girl. Good girl. Mr. Fisher.
Here, there's this one I believe, yeah.
State versus Fisher.
We are on record in the Meigs County Common Pleas Court in State versus Fisher, 26 CR 028. For the record, I'm Linda Warner, the Common Pleas Court Judge. Mr. Fisher, if you would, please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
That's right.
Tell me your name.
Matthew Fisher.
Okay, and you can finish filling that up when we get done. I know it's hard to be doing that and talking at the same time. And that's where I need you to just put your address, phone number, and email if you would.
Okay.
And then your attorney for the record
Rick Wiseman, attorney for Mr. Fisher.
and for the state.
Yes, Your Honor, James Stanley, Meigs County Prosecuting Attorney here on behalf of Ohio, along with Assistant Prosecutor.
All right, and given the nature of the allegation, there would be a victim. Was the victim notified?
Yes, sir.
Victim present? Right, and we are here for a status hearing because I believe the next thing is the jury trial, correct?
That is correct, Your Honor.
And you saw that I did interview the victim.
I did, yes, I received the court's entry on that.
Okay, so, what else do we need to do to be ready for trial? When is the trial?
Trial is set for September 8th at 8 a.m. I guess probably the only thing, I don't anticipate any other jury instructions beyond OJI, but however, I can file, whatever we need to a week before or whatever the court wants to order us to do. But I don't believe I have anything pending.
Okay. Instructions and exhibits. We have all exhibits and jury instructions a week before the September 8th trial. Is that what
Yes, Your
work
Honor.
out? Okay. What else can we do? Anything to be ready?
Your Honor, the state and I have been discussing some possibilities. As of right now, we don't have a deal. We'll continue to work together, I'm sure, up until the trial date, but at this point, I don't believe there's anything the court can do.
Okay, all right, you agree?
That's correct, yes, Your Honor.
Okay, thank you. Then we'll see you here in a few weeks again. Thanks. Do you have any questions, Mr. Fisher?
No.
Okay, thanks.
Thank you. We're a few minutes early on Mr. Conley, but he said it. So
Yeah, did you expect victims on that? Okay, so that's all right.
yeah.
State versus Conley.
We are on record in the Meigs County Common Pleas Court in State versus Conley, case number 26 CR 054. For the record, I'm Linda Warner, the Common Pleas Court Judge. Mr. Conley, please raise your right hand to be sworn. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Christopher Conlon.
And did you write down your address, phone number, and email on a piece of paper?
Yes.
Okay, and is that accurate information with regards to your mailing address?
Yes, sir.
With that then, defense attorney,
Thank you, Your Honor. Rick Wiseman, attorney for Mr. Conley.
will the state,
Yes, Your Honor, James Stanley, Meigs County Prosecuting Attorney here on behalf of the state of Ohio, along with Assistant Prosecutor Attorney LP.
all right, and there would be a victim or victims in this case. Was the victim or the victims notified?
Yes, sir.
Are they present? Anticipated to be? And so, this is a motions hearing. I know there is a motion pending regarding, a request for an competency interview of a victim. So with that, is there an agreement or you want to argue those on the record? No agreement?
That is correct. There is no agreement on that. I would just also note, I do have a motion for a more specific bill of particulars that was filed July 10th. And I spoke with the state prior to going on the record earlier this morning, and I believe that they had no objection to providing that more specific bill of particulars to.
And you agree with that, Mr. Stanley?
Yes, sir.
Okay, so that'll be, when do you think you'll be able to? I know schedule's kind of crazy.
Tomorrow, Wednesday.
I assume that's sufficient?
Yes, Your Honor.
Okay, now your motion.
Yes, Your Honor. I did file a motion for competency of the alleged victim, a juvenile, on July 10th. Essentially, the motion's fairly short. It notes evidence rule 601B that provides a person is disqualified to testify as a witness when the court determines that the person is, one, incapable of expressing himself or herself concerning the matter as to be understood either directly or through interpretation by one who can understand him or her, or two, incapable of understanding the duty of a witness to tell the truth. Further, revised code 27-1301 provides that all persons are competent witnesses except those of unsound mind or a child under 10 years of age who appear to be incapable of receiving just impressions of the facts and transactions respecting which they are examined or of relating them truly. In this case, Your Honor, it's uncontroverted that the alleged victim in the case has a date of birth of 2/25 of 2015. That does place him being 11 years of age at the time that he would be testifying. Obviously, he would not be presumed to be incompetent as he would not be under the 10 years of age mark. However, given the, I guess, the young age of the victim comparatively to others who may testify and ever sit in that seat, the fact that the child's brain is not yet fully developed, won't be for in excess of a decade. I believe it would be even more important and incumbent upon the court to inquire of an 11-year-old their, I guess, the understanding of the proceedings specifically, what essentially the importance of these proceedings are, how important it is to tell the truth, the stakes of this kind of a proceeding, all of those things, as we all, or many of us in the room have raised children. An 11-year-old is, I believe, unless they've ever been in a position where they're testifying under oath, or seated in here in a jury, or in a jury trial, of which most adults had never been. It would be hard to understand how they would be able to grasp the gravity of such a situation. Though I understand he is 10 years of age or older, and not presumed incompetent, I would ask for the court to consider whether there are additional safeguards that the court would deem appropriate, given an 11-year-old's testimony, and the fact that the defense would submit that this case hinges completely upon the 11-year-old's testimony. There is no additional evidence, there's no DNA, there's no admissions, there's nothing additionally that would lead or could lead a jury to find that the state has met its burden of proof beyond the testimony of an 11-year-old. So that we would just ask the court to consider that, all of that.
State's position?
Yes, Your Honor, just very briefly, there's not been a showing that this particular child exhibits anything that would make this child incapable of expressing himself or knowing that he needs to tell the truth, anything suggestive that he's not competent or that he wouldn't understand the proceedings. Certainly at trial, the court could address him and ask him any questions before testifying, but there's been nothing presented either through the motion or argument today that would indicate that Rule 601 or revised code 23-1701 would be applicable, in which it would be proper for this court to conduct an in-camera interview of a child without something more than speculation. Everything we heard today was speculation about children in general. This court's taken testimony from countless children. We've had children testify in criminal cases without issue, without the court having to conduct in-camera interviews of all of those children. So certainly children are capable of being competent witnesses. Rule or not the rule, but the statute specifically indicates under the age of 10. This child has been over the age of 10 for almost a year and a half now. So the child has cleared that threshold that requires a closer examination pursuant to the statute. So without anything further, without any actual allegations or evidence, this child is incompetent or incapable of being able to tell the truth, the state would ask the court not to conduct that interview, at this time, if during court or during the trial, it seems like there might be an issue, surely at that time, but as we stand here today, the state does not believe there's sufficient reason or cause to conduct that in-camera interview.
Okay, any response to that?
There you go.
All right, since your child is 11, I don't think there is any reason. I understood most of your reasons were, to impress upon the child the seriousness of this and the importance of this and the magnitude and mistakes and so on, which I trust professionally that the prosecutor can and will do that, and I can and will impress upon him or her at trial the importance of telling the truth, that we have to totally rely on the truth only, that and those sorts of things. But as far as doing a competency to stand trial, just the child's age being 11 and nothing beyond, wanting to make sure the child was properly advised of the serious nature of it, I don't think that's sufficient, so that's denied. I'll note your objection though.
Thank you.
Okay. Right, anything else we can do? Do we have a status before the trial?
We do not, Your Honor. I believe the trial is set for next Tuesday.
Oh, it's next Tuesday?
Yes.
Okay, so there's another trial that's supposed to be starting Monday. So how are we going to handle that? Did you not know that?
Incarcerated as well, so.
Yeah, they're both incarcerated. I suppose. Is there any potential last minute please on that other one?
Or potentially, we're really falling hard.
Oh, and you have all your witnesses subpoenaed for both trials, I assume.
Yes.
So I mean, I guess it would be that we would have to communicate with you Monday if that one goes.
I'm sure that, I can stay in touch with Mr. Stanley and in the state on maybe where everything stands. Yeah, I understand if the trial starts Monday, it starts Monday.
Right, and you'd obviously need to know because you have a bunch of hearings all afternoon Monday anyway, so.
Sure.
But to keep in touch with Mr. Conley, of course, so he would know. So why don't we have get a backup date just in case, so we at least have a date and it's not pushed out any farther than it would need to if the other trial goes.
Well, I was looking at the very next week, the 25th, but we think Holsinger is gonna go Finley.
Yeah, you'd have to look at otherwise, yeah. What about Penman?
Next week.
It's time to talk to doors for the trial. I'd rather not, man.
We're doing a double book September 1st then, because we only have one that day, which is Hinman.
And she's not in jail.
Okay, so September 1st.
I'd rather get him then because he's in jail. September 1st is the backup date that work for you, Britt?
Yes.
All right, Mr. Conley, do you have any questions?
All right.
All right, then we will see you Tuesday, or if not Tuesday, then September 1st. So either next week, a week from tomorrow, or September 1st.
All right.
Okay, thank you. Go off record then.
Coaching.
All right, do you need anything else?
I think that is,
Okay, let's start saving some of these things.
Hey, Frank, Kenchville doesn't mean,
No.
so he's good to go.
Yep.
This is your last one.
Correct.
Thank you.
Yep, you're welcome. Thank you. Appreciate it. And then did we figure out that Robert Thorla is not incarcerated?
Right, we
Okay.
couldn't find him anywhere.
There's a bench warrant.
I've been for it.
Yeah.
All right. Eight.
Nice, see y'all later.
See you later.
this is,
Hey, Judge.
Yes, ma'am.
Abby texted me while we were on record